number one, two, my lord. I prefer little accommodation for half an hour, my lord. Item number two. Item two.
Today there will be a difficulty because we are taking up, because of the change in roster, we are taking up the APSC matters today. So we'll fix it up on Monday.
Lot, my lord. Lot.
Uh,
126.
who's there for the other side? Who's there?
My lord, Mr. A. Chaudhary, he is there. In fact, I have informed him that I am going to.
Okay. Let him come. We'll pass orders. Mr. Sharma would be here.
Bolo.
Let him be here. We'll pass orders. We'll
Lot.
be adjourned. Yes.
Sir, Your Lordship, I beg to mention item number 5 of the daily list. We are supposed to file an IA, Your Lordship. By today itself, we will file it. So with the consent of the other side, the matter may pass over for the day, Your Lordship.
Type of single bench or division bench? Single bench.
Single bench.
Division is DB.
Obliged, Your Lordship.
Daily list. Item 1 for motion.
Yes, Mr. Vishwas. What is the date of the opinion?
My lord, opinion is 4119. Page
4119.
Page 40. But in fact, I filed it till the 20th, and there it was hard and fixed for order. But sir, it was, we have applied for the certified copy also, but I did not get the order. Suddenly it was listed last month, my lord, and asked me to appear and call for the records, madam.
What is the best document you have to connect you to your projected parents?
Yes, madam, I have given some voter list, madam.
No, not voter list. Apart from voter list.
Voter list I have given, madam.
No, voter list, we don't accept it as a prima facie document of connectivity. Because Mr. Biswas,
Yes.
I respect you and therefore I may have your voter ID also with me. That voter list with me.
My lord, from the judgment, it appears that cross-examination could not be done because he did not appear.
He did not appear.
Time granted. And my lord, regarding other documents, my lord, Panchayat, the president's.
Is there any voter list of you and your parents together?
Yes.
Do you have any voter list with you and your?
Page 24, kindly see, madam.
24.
Muntaz Ali and Johra Khatun is my mother, and Johorul Haq is myself. My age is 24.
Where is your written statement?
Written statement, my lord.
It's 34.
I think.
34.
Well, please come 34
34.
page.
You have not introduced your parents here.
Yes, madam.
Number one, you have not introduced your parents, and in the verification, you are daughter of so and so. Look at your verification.
My lord, Johorul Haq, daughter of Muntaz, son of Muntaz Ali, my lord.
We don't know.
Type became a DU, my lord. I'm sorry for it, my lord.
No,
It
it's
also
okay.
slipped my this. I could not trace out it earlier.
We are trained to see only that.
Yes, my lord. Which will miss, my lord, it has come to your eyesight, my lord. I've seen. When in my evidence chief, I have written my Muntaz Ali, my lord.
No.
Type of the.
You have not stated about the name of your parents. You know something very interesting. In an affidavit, I so and so, son of so and so, aged about so and so, is never sworn on oath.
Yeah.
You will always verify paragraph 1, 2, 3, 4, 10, 100, whatever. But that I am so and so
Yes.
is never sworn
That is
on oath.
also required.
Therefore,
In my affidavit, well, I've given my number. And my,
no, that's why we are saying. You just recollect any affidavit you have
yes, you're right.
made. The name and the parent's name, age is never sworn on oath.
Yes, that is also to be taken into oath matter, yes.
Which page is the opinion?
Opinion is page 40,
40.
40, madam, kindly.
Otherwise,
We grant him bail. It doesn't have a.
yes, there is nothing in this case, my lord, in fact.
But still, we have to hear it. Today, we can't devote that time. We are taking up that APSC matters. We give him bail for the time being. Heard Mr. S.C. Biswas, my counsel for the petitioner. The respondents are there. Mr. Islam on behalf of
hearing.
AI Ali. The pursuant to order dated 25/4/2025, comma, the records of the tribunal is received. Most of the examination of records would take some time. Next, next time, for which we propose to hear the matter on some other day. Full stop. Next, the learned counsel for the petitioner is for bail, which is opposed by the learned standing counsel for the FT matters on the ground that there is no document to connect the petitioner with his projected parents, and there is no prima facie error in the opinion of the learned tribunal. Next, be that as it may, as in view of the projection made in this petition, bail rupees 5,000 to the 10 days time to take bail to the satisfaction of SP border. Bongaigaon.
Border.
Next, para. Issue rule returnable forthwith without requiring any fresh steps to be taken. Next, para. List the matter for hearing on 28/6/2025.
Item 2,
We are adjourning the matter today. We'll take it up some other day. Next week, we are fixing it. 28/5. Both sides are represented. on the prayer made by Mr. Dinath, Senior Government Advocate, the matter stands adjourned today based on 27/5/2025.
It's a. Oh, bless you.
Oh, just a moment, 27/28, there is a fixed matter. 29th,
29.
29/5.
All right.
There's some other matter fixed on that day. Imlak? In this,
In custody, my lord.
he's in
8
custody.
month, 22 days, my lord.
Huh?
8 month, 22 days. as a
8
total.
months.
8 months.
You give him bill then. It's for 8 months. Give him bill. 8 months is long. Had Mr. H. Ali, learned counsel for the petitioner. As all the respondents are there. Pursuant to the orders of the court, the records of the tribunal is received. The examination of records will take some time, for which we propose to hear the matter on some other day. Next para, the learned counsel for the petitioner prays for bail, which is opposed by the learned standing counsel for the FT matters on the ground that the petitioner was granted bail by order dated 8/12/2023. However, the petitioner defaulted in appearing and absconded. Full stop. After a lot of attempts by the border police, the petitioner could be apprehended only on 2/9/2024 and thereafter sent to the transit camp Matia Gwalpara. Full stop. Accordingly, it is submitted that in the event the petitioner is granted bail, there is every likelihood that he would abscond. And accordingly, he submits that the petitioner is entitled to bail owing to his default, which is on record in this writ petition. Next para. Although we take serious note of the conduct of the petitioner, that despite order of bail granted on 8/12/2023, the petitioner did not take bail and absconded. Nonetheless, as the petitioner is detained in the transit camp Matia for more than 8 months, the court is inclined to allow the petitioner to go on bail on the following conditions. Those 3 conditions are there. Just add one more condition that in the event the petitioner intends to go out of the jurisdiction of Superintendent of Police Borpeta, border Borpeta, he would give advance information in writing to the Office of the Superintendent of Police Border Borpeta regarding the period he would be out of station and the place where he would be visiting. Next para, in the event the border police, upon inquiry, do not find the petitioner in his place of residence, it would be open to the said authority to move this court for cancellation of bail. This will be next condition, huh? Next para. Issue rule returnable forthwith without requiring any fresh steps to be taken. List the matter for hearing. In the month of July 2025 after summer vacation. Date to be fixed by the office. Huh? This, you have an IA also?
I.
Bail is in IA. So give bail in IA and then the rule issue rule in the writ petition.
Hello, obliged.
Yes, Mr. Huda. Mr. Huda,
That's it.
we will not be able to hear you today
That's it.
because of the because you're taking up APSC matters. You're not on bail, I suppose.
That's it. Please,
You're not on bail.
that's on bail. That's-
You're on bail. Okay,
Maybe after.
we fix it up after 2 weeks.
Your lordship, please. That's on convenience.
We are sorry to adjourn your matter.
Not that all. That's why I want to apply. That the civil plaintiff. And tell you my prayer earlier for the release of bail persons. He was 9 months, he was languishing there. Unsuspected person.
He was apprehended when?
That's it.
What is the date of when he was arrested?
Month of September. First week of September.
September 2024. Mr. Pang, the proceeding is 69 years old.
He's in bail, madam.
Huh?
He's in bail now. Bail decision, no? Order decision. I took this.
No, we did not grant bail to the petitioner.
Probably in the IA, my lord, it was.
Oh, there's an IA.
Yes, the
Okay.
IA was there, the IA is disposed.
Okay, bail was granted.
Yes.
Okay, I'm sorry, I missed out this. Both sides have been presented. As the court is in the midst of a part-heard matter, the hearing of this matter is adjourned. Next matter. This is the matter for hearing. On 28/6/2025. 28/6/2025. Oh, just a moment.
Six. Sunday, my lord, 20.
Motion was saying.
20.
No, we're making it 15/7 after vacation. 15/7/2025.
Daily list item 5 to 52.
Mr. Huda commands additional respect from the court. He's 90. Mr. Huda commands a special respect from the court because he's 90.
Yes, and still he comes. Great. Very pretty much. And I'm appearing in item number 7 and 28.
Just a Item numbers,
7 and 28.
And 20.
28 पहला दिखा है
Almost.
28.
এটা কোন ভিডিও?
yes, which will be your lead case? Which will be your lead matter for your arguing?
28.
28 will be your lead case.
28.
No, 28. Just one.
My lord, the impugn order of discharge was both, it is appellant in item 7 and 28. Both have been discharged from service and the order of discharge is under
190.
challenge. Now the challenge is on two grounds. The first ground is that in item number 28, Savira Imran, she had completed her probation period.
নীলাটো স্যার
And therefore she was no more a probationer.
In this, the learned single judge has said that despite completion of the probation period, referring to a case, it says that they cannot be deemed.
But the learned single judge relied upon Chandra Prakash Shahi versus State of UP, wherein a specific order was required. But in the present rule which is applicable, there are no such requirements. That I'll take your lordships through that. Then the second ground, my lord, will be that discharge is stigmatic, solely based on police report, and was passed without conducting any inquiry in gross violation of the principles of natural justice. This is a common ground which your lordship has been hearing for all these. So these are the two grounds I would also press. Now, the first ground that I'll place before your lordship is, it relates to the completion of the probation. Now, if my lord will kindly have this 196 of 2000,
We have it.
a paper book of Sabira Imran,
Yeah.
at page 7070, your lordship will find the appointment order. It is dated 21st August 2015. Your lordship's got me.
Yes.
As recommended by the Assam Public Service Commission and upon receipt of this satisfactory police verification report, the governor is pleased to appoint the following candidates to Assam Police Service Junior Grade with effect from the date of joining. My lord will see at serial number 24. Serial number 24. Srimati Savira Imran.
ওকে
Compilation. Yes. Serial number 24, your lordship has seen, Savira Imran. So she was appointed on 21st August 2015. And she was under the rules, she was to undergo 2 years probation period. But if my lord will kindly take up the compilation that I have given. This compilation,
Small one.
yes. My lord, the relevant rules, that is Assam Police Service Rules 1966, your lordship will get at page 1. And the relevant rule is at page 7. Rule 15(1). All persons recruited to the service shall accept persons recruited under 5(2). We are not concerned with 5(2). Be on probation for a period of 2 years from the date of appointment to this service. The period of probation may, for good and sufficient reason, be extended by the governor in individual cases by such period as deemed necessary. Now, she completed her probation period from the date of her appointment on 20th August 2017. 20th August 2017, she completed her probation period. But once she completed her probation period, under Rule 15(1), there were 2 options, or rather 3 options before the appointing authority. 1, for good and sufficient reason, her probation can be extended for a further period of 2 years. Or she can be told that we are not satisfied with your performance and you are not suitable for the post. And therefore, she could have been discharged. But these options were not exercised. Rather, she was transferred, my lord, as assistant commandant to Assam Police 12th Battalion, Jamuguri Hat. And that order, your lordship will find at page 81. Page 81. This is order dated 15/9/2017. 2017. 85. Your lordship will come to 81.
Yes.
But what is important at page 81 is this is an order by the governor. And the relevant page will be 85, my lord. So this is an order by governor And at page 85, if my lord will kindly come to serial number 3 from top panel. In the interest of public service, Srimati Savira Imran APS is posted as Assistant Commandant AP Battalion Jammu Guri Hat against existing vacancy with effect from the date of taking over charge until further order. This was her posting order. What is immense importance is, my lord, the last paragraph at page 85. The above posting of APS Junior Grade 2015 batch have completed probationary period of 2 years. And are exempted from mandatory posting in the battalion for 4 months as per notification dated so-and-so, as their services are urgently required in the field in a specialized agency, CID, border, so-and-so, so-and-so, due to shortage of officers. But this is an order by governor which says the probation is completed. But I ask a question to myself. If governor in its order says probation is completed, can it be said that it was unsuccessfully completed? No probation can be, my lord, said to have been unsuccessfully completed and the person still is in service. So, completed means successfully, to the satisfaction of the governor, she has completed her probation of 2 years. There cannot be any other interpretation, my lord, in my humble submission. Now, thereafter, my lord, she got the last increment, the second increment, because under Rule 21(1), 2 increments. One was during the probation period, and the other will be after confirmation. I'll take your lordship through. If your lordship will kindly take this compilation, small compilation, my lord, at page 9, my lord. Page 9.
Yes.
I'll place Rule 21, my lord. The first increment to a member of the service in junior grade timescale shall accrue on the expiry of 1 year from the date of his joining service, but further increment due shall be admissible only on his confirmation to this service. Now, we have made a specific averment in paragraph 18 of our writ petition that she got these 2 increments. Now, your lordship will take up the paper book. The appeal, my lord, paper book 196 of 2020, your lordship, and turn to page 56. The writ, my lord, starts from page 39. And the relevant paragraph 18 will be at page 56. It is stated that during their service period, the petitioner received 2 increments, and hence, in terms of Rule 21(1) of the rules of 1966, their services stands confirmed, and those things are there. But these are an averment made about 2nd increment that we have received. Now, this hasn't been denied, and that your lordship will come to page 175 of the same paper book. The AO of the state starts from page 144. This is dated 25/7/2019. The relevant will be, my lord, at page 175. Actually, the paragraph 78 starts from 174. But I'll just, my lord, take your lordships. Yes. My lord, at page 174, if your lordship will see 13 lines from top. Page 174.
Yes.
In every such cases, as has been held by Honorable Apex Court, the individual concerned whose selection is stinking, conceived in fraud, delivered in deceit, has no place, as fraud unravels everything. Every such individual will have no right to go to public office and would also be liable to disgorge the benefit of ill-gotten gains, which would also include the salary perks which any such individual has received by virtue of such fraudulent secured appointment to public office. As such, having regard to the principles of law laid down by Honorable Apex Court in relation to these cases, while securing the appointment to a public office by fraudulent process, all such contentions, including the contention of securing annual increment, would be completely inconsequential and would have no bearing at all in relation to legality or validity of the discharge order passed by the employer in a state in relation to such person. I'm only trying to show your lordship that this hasn't been denied. They say even if you have got, it is of no consequences. It's inconsequential. And my lord, I will tell my lord one thing before your lordship. (1994) page 280. Yeah, page 97. That is still there. 94 4SS. मिल गया हमको कर लीजिए चलिए बोलते हैं पढ़ा करो. But your lordship has seen in every paragraph they are saying the entire selection is stinking, conceived in fraud and delivered in deceit. But this has got nothing to do with the facts of the case. Rather, these are borrowed expressions, I'll say. Your Lordship will kindly take this. I'll just show the expression which is being used, and these are to prejudice the court. Your Lordship will take this and come to page 87, my lord. 87. Your Lordship will come to, my lord. My lord, I am sorry, I cannot hear. If your Lordship will just put that mic little louder. He also has not heard. But it's very slow. Not that I have become deaf. Ah. Yes, yes, my lord. My namesake. In both the cases. One was 3 judges bench headed by my namesake. Yes. And that too, my lord.
This couldn't be online.
Singapore.
This couldn't be online.
But I knew immediately. It's an open thing, then. Open thing. Your Lordship will come to page 97. 97. Paragraph 20. Paragraph 20, I'll place, my lord.
Yes.
In the above circumstances, what are we to do? The only proper course open to us is to set aside the entire selection. The plea was made that innocent candidates should not be penalized for the misdeed of others. We are unable to accept this argument. Now from here, this starts, my lord. When the entire selection is stinking, conceived in fraud, delivered in deceit, individual innocence has no place. So, my lord, they have used these expressions not on the basis of the facts disclosed in these proceedings, but this has been lifted from the judgment. With great respect, this is to prejudice the court. Now, my lord, when the appellant, my lord, was posted as Assistant Commandant Jamuguri Hat, she was arrested on 8th of November 2017.
What do you
Oh. Charge-sheet क्यों देंगे? Lord, the suspension order, your Lordship will get at page 134. Well, one thing I may tell, if your Lordships find that I'm repeating something because I have not heard other argument, your Lordship will tell me, I'll skip over. At page 134, whereas a report has been received from Superintendent of Police Dibrugarh.
You may not read it. We understand. It's a order of suspension
Yes.
post arrest.
Yes, post arrest. And this was specifically under the rules that your Lordship has seen.
Yes.
Now, thereafter, my lord, the discharge order followed. And the discharge.
Because this order is under 6(1) of the Assam Discipline Service rules.
Yes. Thereafter, my lord, the discharge order was followed. And one thing new which I will show here, my lord, with reference to this case, your lordship will kindly turn to page 135.
Just a page 134. After that, which page?
35.
135. Yes.
The Governor of Assam, in exercise of power conferred under Rule 16B of the Assam Police Service Rules 1966, is pleased to discharge Srimati Savira Imran APS, kindly mark it, probationer. Probationer.
Yes.
At page 81, if your lordship remembers, or your lordship can go page 81, my lord, for a second. This is also an order by governor.
That page 85 you are referring
And
to.
85, relevant is 85, completed probation. If I have completed probation, how come I am a probationer? In my humble submission, my lord, there is a ploy, and I will disclose a little later why they have used this. Because I have completed my probation, this is their own record shows. Now they say that I am a probationer. We came to know why we are being referred as probationer after the state affidavit was filed in this writ, my lord. This was filed, my lord, on the state affidavit was filed on, AO was filed on 25/7/2019. I will, it starts at
A
page
of respondent
144.
numbers 2 and 3.
My lord,
A of respondent numbers 2 and 3.
2 and 3. One, actually, there is no affidavit, AO, on behalf of the government.
No, we understand, but since we are following you,
Yes, yes.
earlier you referred to this page 156, that is of AO are respondent number 2 and 3.
Yes. Yes.
Same, you are
Yes,
referring to same
yes,
affidavit.
yes, same affidavit. Same affidavit, my lord, 2 and 3.
Was filed on?
This was filed on 25/7/2019.
Yes.
Yes.
Now, my lord, will come to page 158. Paragraph 40, my lord. 158. Paragraph, just above paragraph 39, your lordship will see the caption extension of probation. Your lordship will come to 40. Without prejudice to the aforesaid position of law, it is submitted that by another notification dated 20th January 2018, the period of probation of the petitioner was extended.
Yes.
Now, the extension order your lordship will get at page 178. 178. There is an actual R1 to this AO. Srimati Savira Imran, APS officer, was appointed on probation to Assam Police Service on 12/10/2015. I think the date is wrong. Maybe it is typed one. Whereas an investigation by the Dibrugarh police is going on in the recruitment of APSC and the other allied service officers of 2015 batch. The government is not in a position to form requisite satisfaction in respect of Sabira Imran. Therefore, the service of the above mentioned 2015 batch officer is not proposed to be confirmed at this stage. Therefore, the governor, in exercise of power so-and-so, is pleased to extend the period of probation of so-and-so for another 2 years or till completion of the investigation. Now, your lordship will just note a few dates which I'm pointing out. Your lordship, as she was appointed on 21st of August 2015.
Just a query.
Yes.
If you are referring to this page 178.
Yes.
But then the change of status from confirmed in service
Yes.
to probation,
Yes.
that has not been assailed otherwise.
So what we have said is this is a manufactured document.
Okay.
And we have filed a separate writ petition that also is before your lordship. That is writ appeal 333 of 2021.
Which 43 items.
The item number 43.
Mr. Prasad, you remember the case number, writ petition number?
Writ petition number is 7122 of 2019.
This was dismissed and then appeal.
Then by the common judgment matter. Common impeach judgment.
Writ appeal number?
Writ appeal number 333 of 2021.
Now, my lord, I'll give your lordships 3 dates just to make a point. Her appointment is on 21st August 2015. She completed 2 years on 20th August 2017. The extension order, which I have just taken your lordships through, was passed on 20th January 2018. There is a gap of 5 months. In what capacity she was permitted to stay? That is a question that I ask myself.
In between.
Please repeat again. The confirmation order was, last order was,
My lord, the
not this one, the last order of confirmation,
uh,
85, page 85.
page 85 was 15/9,
2000.
2017 at page 85. When say that probation is completed. Now, my lord, when we say that it's a manufactured document, we have our regions. One, there is no explanation as to in what capacity she continued from the date of completion of her probation period till this another extension. From 20th/8/2017 to 20th January 2018, it's good 5 months. What capacity she was in service? She was drawing her pay, everything. Then your lordship will come to page 178 once more. Your lordship will see the copies are endorsed to about 17 high officials. And then serial number 18 is for the concerned person. Now, none of these 2015 batch, I'm representing just one, none of them received this order. And therefore, they were surprised. What is this? We have completed our probation period. The governor has said, where from this extension comes? Then what they did, they took recourse to Right to Information Act, Section 5. And they wrote to all these officers that kindly provide us your register where you receive these kind of orders, and also give me a copy that you have received. They said, no, we have not received any. Your lordship will come to page 150, 150. Yes, I'm sorry, but of this your lordship has to see 333. 333.
Item number 43.
Before the learned single judge, I was not in this case. And even now I'm not there. Your lordship will say, page 150. In fact, panel, there are two extension orders. One is 20th 1, 2018, and the other is 30th 12, 2017. So different batch. All have applied by law under RTI and got the answers, as I said, that no such thing were received. I can give my lord the RTI question. The request starts from page 95 to 148 of this. I'll just take a lordship through one. And the answer given is from 149 to 162. We made a request under RTI from all the appellants rather, from 95 to 148. And the reply that we got was 149 to 162. One 149 to 162. I'll take my lord few.
No, one is good enough.
Yes. Now your lordship will kindly come to page 150. 150. This is Office of the Additional Director General of Police, TNAP, at page 150.
Yes.
He wrote, my lord, to one of the appellant here providing documents under Right to Information Act 2005, with reference to the subject cited above, I am directed to inform you that after checking our record, it is found that letter number so-and-so dated 21/2018, this is the letter one, have not been received by this office, hence we are unable to provide. This is from the Director General, Additional Director General. This is a manufactured document.
Okay.
My lord, then your lordship may turn to page 161. This is by the Assam Administrative Tribunal. The copy was endorsed to all these officers, my lord, and the tribunal.
161,
161, my lord. Is, my lord, his endorsement is at serial number 3 of page 178. Well, with reference to above, I am to inform you that no notification of his bearing dated 21/2018 issued by so-and-so have been received by this office till date. And this is, my lord, 30th August 2019. They have not received. Now, the last one I will show is, because these are, my lord, supposed to be notified in the official gazette. Now, it was endorsed to them at serial number 14. It was endorsed to Government Press, my lord, and your lordship will come to page 162. This is Government of Assam, Director of Printing and Stationery, Assam, Guwahati. With reference to the letter cited above, I would like to inform you that after checking the receipt register of this directorate, it is found that letter number so-and-so dated so-and-so issued from Home Aid Department, Government of Assam has not been received by this directorate. It was under these circumstances that we filed a separate writ petition, my lord. When the matter was last heard by the then
Because-
Chief Justice,
it would only be a 127, it would be presumption of posting, not presumption of receipt.
yeah, debatable presumption if they show this CTS. Now, my lord, so I'll just tell your lordship, the matter was taken up by.
Again, this is relatable to 114, illustration E.
Yes.
All official and judicial acts are duly performed.
Yes. Yes. Well, Lord, the then Chief Justice Sandeep Mehta asked them, did you publish it in the Gazette? They took time to produce. Then they said, no, it is not there. Because the copy is endorsed to the Director of Printing Press, and he says we did not receive. The question of printing doesn't arise. So therefore, these are a made-up document. They must explain. 15th Governor says, I have completed my probation. Then subsequently on 20th January 2018, you say you're under probation. And we made, my lord,
Are you suggesting that those authorities are not trusted authorities?
my lord, I'll tell about the history of this case. This case was proceeding, my lord, as people are, even the officers, my lord, that way they don't resort to any trick. But then something happened, some people came, and then all these things happened. The tone and tenure is changed. I'll take your lordship to the first affidavit that was filed. And thereafter, how the tone has changed. Because some two big wigs were fighting, and then these boys, my lord, they suffered. Under pleading, we have made in paragraph 15 at page 48 of this Read appeal 333, Milord. 28. Mhm. We have made a specific plea.
In this 333, page number?
Page number 48. That it is humbly stated that being left clueless by the impugn notification referred to above, the petitioner filed application on the Right to Information Act 2005 to all the parties to whom the copies were marked in the notification itself. In the response to the RTI application, the authorities concerned have replied that the impugn notification extending the period of probation of the petitioner has never been received by their respective offices. In the humble understanding of the petitioner, the said fact fortifies the claim of the petitioner that the impugn notification had been issued, antedating the same, in order to project the petitioners as probationer so that they can be deprived of the protection envisaged under Article 311 of the Constitution. The cause espoused in the writ petition challenging the discharge order can be defeated by whatever means possible. Now the reply is at page 193.
202.
193, my lord. Reply to paragraph 14 and 15. Same affidavit, same paper book. Paragraph 75 at page 193. A small paragraph. Bare denial. The contention of paragraph 14 and 15 of the writ petition are denied being incorrect, misconceived, and misleading. It is specifically denied that the extension of probation of the petitioner is an afterthought and that it has been passed behind the back of the petitioner. It is respectfully submitted that the extension of the probation of the petitioner has been done strictly under Rule 15(1) of the Assam Police Rules 1966. The allegation of victimization and extension of probation being an afterthought and antedated, the extension of probation orders are specifically denied being incorrect, misconceived, misleading, apart from being baseless. The extension of probation have been issued by the state government entirely in accordance with law, and the judgment of this Honorable Supreme Court in this regard, the orders have also been placed before the Honorable Court along with affidavit of the competent authority of the state government, and all contentions are contrary or incorrect, misconceived, unsustainable, etc. So that's bare denial. Because they cannot say that we have done it, but they have done it. Fact remains that they have done it. Now, on this point, I'll come to the last part, Milo, of my submission. I hope I'll be able to finish. No, I'll come to the
But,
last leg on this
bu-
point,
But you see,
my lord.
once you are there at page 193, page para 75 and 76 you have read.
Yes.
Can you come to page 212? This is a part of your reply. This perhaps is not happily worded.
200 your lordship said.
212,
1, 2.
70, para 17 and 18.
The statement in paragraph 75 of there being based on figment and so on, so on, so on. So this is our reply, it seems. Yes, I've not seen it. Speak volumes about unfairness, arbitrariness.
You can read for yourself. It's not very happily worded
That's
for a
correct.
reply.
That's correct. Sometimes people are
No, I'm not asking for anything. I'm just
taken away. But then one thing has to be, well, they're psychic. Now they're totally broken. Some of them are totally broken. And I don't know, but fact remains that they have not explained. They have not explained, number one, about the transfer order which says they have she has completed the probation period. They have not said anything. They should say, if they are very fair, they should also say how that 5 months will be treated. Therefore, Lord, my submission would be there is something wrong. There is something more than meets the eyes. What was the necessity of that order, my lord? I'm just asking myself. And they should have now.
We have forgotten the part. I think this grade 1 officers, their this transfers posting and their notifications are normally issued in part 3, part 1,
Gadget.
chapter 3 or part 3, something like that. I forgot. No, it's, what the query is that what happens if such notifications are not gazetted? What will be the effect?
Well, look, the first and foremost thing is whether this order existed. Whether this order is
For the time being, we presume
generally-
it is there. For the time being, we presume it is there. Then
Right.
we'll come back to your submission.
Right.
But we just wanted to know what is the effect of a notification of class 1 officers not being gazetted.
But the rule requires that it should be so that everybody knows about it. After all, publication in a gazette is for everyone to know. It gives also transparency in the functioning of the government, and everybody should know. Now, here is the case, my lord. It's not only that question, my lord, with all respect, would have been relevant if this was a fact. In fact, it was issued and it was received by the director of printing and stationery, and by mistake it was not published. That time, the lord should have decided what will happen. Our total point of submission is that this is a fake document, this is a manufactured document. You have endorsed it to your old additional DGP. He says we have not received. You have sent it to the administrative tribunal. He says not received. None of them have said that we have received. Therefore, my lord, the main point is that this is a manufactured document just to nullify the earlier order without making any reference to it. They should have said that no, the governor was wrong earlier, now the governor is correct. They cannot wish away, my lord, order dated 15/9/2017, which says that we have completed our probation period. They cannot wish it away. It will be there. Now I'm coming to the finding of the learned single judge. Now on these points, my lord, on the publication and those things, I have not seen any finding. But what the learned single judge has said, that unless there is a specific order of confirmation, there is no confirmation. Your lordship will turn to page 291 of the judgment and order. This same paper book, my lord, 196. 196 at page 291, my lord. This will be a case of its own, my lord.
Yes.
I'm placing 55 at 291. The argument placed on deemed confirmation in service either on account of having completed initial probationary period of 2 years in some cases, or due to name of some of the petitioner appearing in the final gradation list, or the word probation not being mentioned against their name in some of the official documents, or the second increment having been paid to some petitioner, which increment is allowed only on confirmation in service in terms of Rule 25 of 98 rules. The fact remains that there are no orders passed by competent authority in respect of any of the petitioner towards confirmation of their service. It is seen that service rules relevant to the case had the expression of satisfaction of the appointing authority has preceding confirmation in service, which is singularly absent in the case of petitioner. In my respectful submission, there is total omission to consider the transfer order dated 15/9/2017, page 85, the last para. Law does not permit automatic confirmation in service due to efflux of time unless service rule governs the servant specifically lays down that condition. There cannot be any question of deemed confirmation merely on the ground of continuation of service beyond 2 years of probationary period. The case cited by Mr. Singh on behalf of the respondent on the legal principle above comments acceptance by this court. Reference is made to paragraph 11 of Chandraprakash Shahi, wherein legal position was reiterated that permanent status can be acquired only by a specific order of confirming the employee on the post held by him on probation. This court also finds great force in the submission of Mr. Singh justifying bona fide action in the state discharging and removing the petitioner from service. Now, what the learned single judge has missed is that probation, there is an order saying that probation is completed. I'm not on. On deemed confirmation, the lordship knows that decisions are decision others will depend on the rules. Now, in some rule, my lord, if the maximum period of probation is mentioned, which is not the case here, maximum period of probation say 2 years. So 2 years he completes, he is not discharged from service, he continues. The Supreme Court asked, my lord, that In what capacity did he continue? He could only continue as a confirmed employee, and therefore the deemed confirmation came in, where the maximum period is fixed. Now there are rules where it says that the period of probation is 2 years, which may be extended. Now therefore, since there is a provision for extending, there is no question of automatic confirmation because it can be extended. Then, my lord, the third type of cases that I have come across is where the probation period is mentioned, extension period is mentioned, but there is a clause that there has to be a specific order of confirmation. Now, whether after completion of the extended period, whether he'll be confirmed. So the court says no, unless, because the rule provides he has to be confirmed by a specific order. So these are the three types of cases which I have referred. But here, this is a unique case, my lord, where probation period was 2 years. And for good and sufficient reason, it can be extended to 2 years. So when the appellant completed her probation period, it was not extended. What they said is, the governor said that you have completed the probation period. So she has completed. Now after that, in what capacity she can continue in service if she has completed? This is one. The second is whether Rule 17, which provides for confirmation, lays down any condition that there has to be a specific order. I'll place, if Rule 17 says, yes, there has to be a specific order, then she will continue in that capacity till she is confirmed. So I will take your lordship through Rule 17 of the APS rules. My lord, before that, I will take your lordship through Chandra Prakash Shahi's case. That's important. Chandra Prakash Shahi's case, my lord, your lordship will find in this compilation, page 48.
Yes. Your lordship will come first, see the rules. Rule, it's a paragraph 542 of UP Police Regulation, and that is quoted in paragraph 9, my lord. Paragraph 9, your lordship will get at page 55 of the judgment. Judgment starts from 48, my lord. Your lordship has seen that. Now, your lordship may kindly come to page 55. I'll place paragraph 9. An assertion that on completion of the period of probation, the appellant has acquired permanent status is based on misreading of the provision of paragraph 541 of the UP Police Regulation, relevant portion of which is quoted below. Recruit will be on probation for a period of 2 years, except that then B, just below B, my lord, your lordship will see, if during the period of probation, their conduct and work has been satisfactory and they are approved by the Deputy Inspector General of Police at the end of the period of probation for service in force, the Superintendent of Police will confirm them in their appointment. My lord, in this circumstances, under these rules, because if my lord, the three requirements. One, that the probation period she has performed satisfactorily.
And the second most important is that it has to be approved by the Deputy Inspector General of Police. It can be done only in writing, my lord. Verbally, he will not say, because file will go to the person who is competent to confirm him in service. That is the Superintendent of Police. And after the Superintendent of Police receives this, then he will confirm. Then unless it is done, it cannot be said that she is confirmed.
Take a short break and come back.
I have taken your lordships through Chandra Prakash Shahi, that UP. Now I'll take your lordships through the relevant rules in this case. Your lordship will kindly turn to page 7 of this compilation.
Rule 15, you have referred to.
17.
17. Yes.
At page 7. A person appointed to the service shall be confirmed in the service if he has completed his probation, if any, to the satisfaction of the governor. This is the first condition. Second is, if he has passed departmental examination and successfully undergone the course of training prescribed for him. Some spelling mistake, some sentences are missing words. C, he is considered otherwise fit for confirmation by the governor, provided where member of service is not given opportunity for undergoing the prescribed survey or settlement training during the period of his probation, his confirmation shall not be held up for reason only of not having undergone such training by such person when called upon the governor and opportunity given successfully undergone such training. Provided further that the governor may, for good and sufficient reasons, temporarily exempt a member of the service from passing any one or more of the prescribed examination and confirm him in service. A member of the service may be confirmed in the senior grade. There we are not concerned. In my humble submissions, my lord, the 17(1)A is complied with, that he has satisfactorily completed his probation period. And so far as B is concerned, well, she has not passed departmental examination that I was specifically asked. She has done that. But my submission would be that once the governor says that she has completed her probation, that will imply, my lord, the exemption is already there. And this rule will not require any specific order of confirmation. This is my humble submission, Your Lordship. Because once she has successfully completed her probation, and she's continuing in service, posted, she will be, this is the case where she will be deemed to have been confirmed. Otherwise, she cannot complete, her service is not extended. Order dated 20th January 2018 is non-existent, it's a manufactured document. So if Your Lordship is convinced that that document is a manufactured document, because it hasn't, number one, it hasn't been endorsed to anybody, nobody has vouched for its endorsement or receipt. It is also not published in Gazette. All these things point out that this is a fake and manufactured document. And if that is so, if Your Lordship finds that, then, my lord, in what capacity she will continue from the date of her confirmation, that is, my lord, 20th August 2017. So then my humble submission would be, my lord, that she has completed her probation successfully. And therefore she was not a probationer in any case. Otherwise, they will have to explain under what circumstances they have themselves written that she has completed her probation and posted her after. Now, this is, my lord, the first ground of my submission.
Answer is there in the General Clauses Act.
My lord.
Power to do is, power to undone is already there.
But it hasn't been undone. So therefore, it hasn't been undone. And in this case, my lord, I don't know whether the General Clauses Act, because the provision is there. If there is a specific provision, the Lordship knows I don't have to say. If there is a specific provision, then how the General Clauses Act meaning will be taken from. Now, my lord, I come to the next point, which has been extensively argued before Your Lordship. And my lord, as I said in the beginning, if Your Lordship finds that it has already been done and I'm repeating it, Your Lordship will just tell me I'll stop. My lord, I will, on the second ground, I'll say, my lord, that the discharge order which I have placed before Your Lordship, page 134. 134? 135 minutes. 135. It's an innocuous order of discharge. Violation 3, there is no agree. 348 is 348.
line.
ये निकाल Well, look, as I said initially, when the matter was taken up, the affidavits were filed. And one affidavit I will, AO, I will rely is that filed by Ikramul Hussain. At that point of time, he was joint secretary to the government of Assam, my lord. Your Lordship will find at page 3 of this compilation, stick file, my lord, which we have given.
Otherwise, there will be, I had submitted a compilation, my lord, that is at 348.
Paper
With
book
that-
one. The first compilation.
The first compilation that was
Paper book.
single one. That was submitted before the single
book
judge.
one.
So we have,
This one.
yes.
It's okay, we can take it from here.
My lord,
We can take it from the new compilation.
yes, yes, that's right. It is there, but I'm just telling, my lord.
Okay.
Paragraph 5, I will place before your lordship. Paragraph 8, there I'm going to. The relevant paragraph 5 is at page 4, my lord. My lord, as I proceed further, your lordship will be surprised to see that the learned single judge himself said that foundation of the discharge order is the misconduct. And again, he says, no, it is not misconduct. I'll show, my lord. But I'll placing 5. That with regard to the statement,
Yes.
that with regard to the statement made in paragraph 6 to the writ petition, the deponent begs to state that Superintendent of Police Dibrugarh, while later dated so-and-so, 17/6/2017, has reported on 27/10/2016, complainant Dr. Ansumita Gogoi of Parvatpur, PS so-and-so, so-and-so, an FIR to the effect that accused so-and-so of Naya Bazar so-and-so contacted her over phone and asked her to pay 10 lakhs to recruit her in the post of dental surgeon conducted by APSC, in which she appeared. Accordingly, Dibrugarh police caught the accused persons red-handed while taking the money at his residence at Circuit House, Road, Dibrugarh. During the course of investigation of the case, a number of accused were arrested, including Rakesh Kumar Paul, the chairman, Sri so-and-so, so-and-so. As per report of the Dibrugarh police, Sri so-and-so was all found to be involved in the case and arrested on 3/5/2017. It is reported that Sri so-and-so got the job of Assam Civil Service by adopting unlawful means in collusion with the arrested accused persons, Sri Rakesh Kumar Paul and other members of APSC and other officials and agent of APSC. And during investigation, sufficient evidence were found against him to prosecute them in the case. The report says that custodial interrogation of the petitioner has corroborated modus operandi to the extent of racket run by Rakesh Kumar Paul and other associates for providing job to the government of Assam conducted by APSC in lieu of cash and not in on the basis of merit. So this is the beginning, my lord. From here, the investigation started and all the appellants before your lordship were arrested at some point of time or the other. And the allegations are given in supplementary charge sheet. There were as many as 11 supplementary charge sheet. They were all arrested and then discharged from service. But the beginning is this.
I think 14, somebody told us 14.
My lord,
14 supplementary charge sheets.
subject to correction, my lord. Your lordship may be correct. Your lordship is seeing. This is our old information of 11, but yes, maybe.
14th charge sheet, Lordship,
Yes.
supplementary.
Yes, yes. Now, my lord, in the beginning, the discharge orders contain everything, why they are discharged. But slowly, my lord, as the state got wiser or they were advised to be wiser, they were
Or advised by wise people.
wise people. So wise people, they say, don't write anything. And Mr. Kohli is laughing. Don't write anything. You are committing a mistake. Just write your discharge from service. But in any case, form of the order doesn't matter. It may be a cloak or a camouflage for an order of punishment.
I will show my lord how things developed. Your lordship may take compilation 2, that stick file, my lord.
If Lordship will permit me for a minute, and I will thank Mishra sir. He said the same thing in the before the learned single judge also, that there was some good advice that came from Delhi.
Mr. Kohli,
You
I
may
know-
not be the targeted person, but
I am not. Mishra sir has always been very kind to me. There is no question about
Sir,
it.
he is a ferocious reader of the book, and he must have read, my lord, Where the Eagles Landed.
It was a good film.
Not only good film, it
Great
was
book.
an assassination attempt on Churchill. There is a novel. Novel is better than the film.
nobody is better than the movie.
Always.
Yes.
Yes, it is.
Yeah,
That movie
always.
is.
So,
I've been holding a list of 15 movies which are a must for lawyers, and I've been able to watch only one.
Since Lordship has mentioned it, then it will not be injustice on our part to request Lordship to share those 15 movies.
there was one film I remember, My Cousin Vinny.
My cousin Vinny,
Oh,
that's what
very
I've
good film.
seen, but there are 15 list of 15 movies I have collected.
Yes.
My cousin Vinny also says it reconfirms even in law, for a successful lawyer, there has to be a lady behind the good counsel.
They're too expert in motor vehicle. Now, my lord will kindly come to page 10. I'll not take your lordship, I'll just say your lordship to just glance the changing tone of the state. This is at page 10, this is a suspension order. Your lordship will find detailed, my lord, here. Why he was suspended, because of the police case, and then how his services are being dispensed with. Assam Service Discipline and Appeal Rules. Very 10. Okay. Now, if your lordship will see the last paragraph, 20C. इसी में है? आगे देखिए। Now, therefore, the Governor of Assam, in exercise of power conferred by Rule 20C of the Assam Civil Service Rules 1998, read with 10.2 of Assam Service Discipline and Appeal Rules, is pleased to discharge so and so, so and so. Now, your lordship will see 20C. 20C, your lordship will get at page 2 of the same compilation.
Mr. Prasad, you can mail a copy to Mr. Kohli.
Will
Thank
do.
you, Lord.
Will do it. Will do.
Or WhatsApp on my phone. Mishra sir has that.
It's
Whatever is-
it's voluminous. WhatsApp would not be very convenient.
I'm grateful for that, Lord.
62 pages.
The compilations will send. One to his has, because this was given earlier before the
Okay.
division bench. So
This has all the charge sheets.
No. This is decisions, mostly decisions. This we have given it to you
Yes.
when the matter was heard by court number 1.
But I will request Mishra sir to be indulgent to us once more.
Name you want, you take, sir. Now, I'll read ballot 20C. Discharge of a probationer. A member shall be liable to be
That is at which page?
at page 2 of the same
Compilation.
Yes.
Okay.
A member of the service shall be liable to be discharged from service. I come to C. If any information received relating to his integrity, age, health, character, antecedent, the governor is satisfied that the probationer is ineligible or otherwise unfit for being member of the service. And this is read with 10.2. 10.2 of Assam's Service Discipline and Appeal Rules.
Yes.
Now, your lordship will turn to page 61, where we have annexed, my lord, the Assam Service Discipline and Appeal Rules 1964 at page 61. And on Rule 10 provides for a special procedure in certain cases. Notwithstanding anything contained in Rule 9, your lordship will come to 3. That's what is mentioned in the last paragraph of the discharge order. Where governor is satisfied that in the interest of security of the state, it is not expedient to follow such procedure, that is holding an inquiry. This your lordship will find in proviso to Article 311(2), same provision. So therefore, now your lordship will kindly see 20C and 10(2), Roman 2. 20C, my lord, some information is received, no inquiry, nothing, the provision is there, and he is discharged. So these were the initial orders of suspension. Then similarly, my lord, at page 11, 12, similar orders are there. I need not trouble your lordship. Now, as I submitted before your lordship, that the form of the order is inconsequential. It's not conclusive. It may be a camouflage or a cloak behind, my lord, the real reason. And for that, I will, my lord, rely upon, there is a case, Siv Vikshuk Mishra, 1972 SCC 871, paragraph 5, at page 43 of the same compilation, 43. Well, the decision starts at page 43 of the stick file, and the relevant is page 44, paragraph 5. May I place it, ma'am? Five. We are unable to accede to the contention of the appellant. Appellant was the state of Bihar, my lord. We are unable to accede to the contention of the appellant that the ratio of the above decision is that so long as there are no express words of stigma attributed to the conduct of a government officer in the impugned order, it cannot be held to have been made by way of punishment. The test, as previously laid down, and which was relied on whether misconduct or negligence was mere motive for the order of reversion, or whether it was very foundation of that order. It was not found that the order of reversion was based on misconduct or negligence of the officer. So far as we are aware, no such rigid principle has ever been laid down by this court that one has to only look at the order, and if it doesn't contain any imputation of misconduct or word attaching
a stigma to the character or reputation of the government officers, it must be held to have been made in the ordinary course of administrative of routine. And the court is debarred from looking at all the attendant circumstances to discover whether the order that has been made by way of punishment. The form of the order is not conclusive of its true nature, and it merely be a cloak or a camouflage for an order founded on misconduct. It may be that the order, which is innocuous on the face and does not contain any imputation of misconduct, is a circumstance or a piece of evidence for finding whether it was made by way of punishment or administrative routine. But the entire circumstances preceding, your Lordship will see, the entire circumstances preceding and attendant on the impugned order must be examined, and the overriding test will always be whether misconduct is a mere motive or is the very foundation of the order. And I will show, my lord, as I have said, there is a finding by the learned single judge that this is foundation. Now, my lord, I will place what is the respondent's case. Are they saying that this is...
Please expand this two words, motive and foundation.
Yes.
What are the two
Yes,
connotations of this?
definitely means, my lordship. My lord, motive could be, as I understand, my lord. Let's suppose there is some information that Mr. A, who is on probation, is doing these things. The employer may not inquire into the matter. But at the same time, he says, look, this has come. I don't want to continue with it. That will be motive. On the other hand, if there are allegations that he has done this, and the master relies on it, and then discharge him from service, that will be foundation. Otherwise, Supreme Court says, my lord, that the dividing line between the two is very thin. It's overlapping. I'll place those decisions, because the other day I saw my learned friend Mr. Benudas placing Dipti Banerjee case. Now, Dipti Banerjee case I'll place, my lord, later when I think. So that is the position. Motive and the foundation. Now, what is the case of the respondent? That will throw light whether it is motive or it is foundation, the fact. After all, it is factual matrix, my lord, which decides the case. And what is the respondent's case? I will start from paragraph 48. I'll place, my lord, 4-5 paragraphs to show what is their case. My lord may come to page 162. The affidavit in opposition dated 25/7/2019, which starts at page 144. I am referring paragraph 48 at page 162. Few paragraphs, small paragraphs, I will place before your lordship, just to, my lord, get a glimpse of what is the case of the respondent.
One 162.
162, my lord. What? Paragraph 48. While the petitioner was serving on probation, the respondent by notification dated 27/7/2018 in exercise of power conferred under 16B of Assam Police Service Rules 1966 discharged the petitioner from service with immediate effect. This is without prejudice to the submission that all the cases in the present batch of writ petitions are cases of securing appointment to public office by fraud. This cannot be motive, this is foundation. And the petitioners are not entitled to remain in those public offices. And all contention in relation to probation, protection of 311 and other principle of service law, etc., applicable only to the cases where there is no question mark on the process of selection and securing the appointment are not at all available to any of the petitioner, and all the writ petitioners deserves to be dismissed. So this is the first paragraph. Your lordship has shown that tone and tenure, my lord, can't be a motive. It's a foundation. Now I'll take your lordships to paragraph 60 at page 166. Having said that our entry is because due to fraud, they say this is simpliciter. At page 166, paragraph 60. Without prejudice to the submission that all the cases in the present batch of petitioner are cases of securing appointment to public office by fraud, and the petitioner are not entitled to remain in those public offices, and all the contention relation to, I think this is repetition, probation, protection of Article 311 and the other principles of service law, etc., applicable only in those cases where there is no question mark on the process of selection and securing appointment, are not at all available to the petitioner. It is respectfully submitted that in the present case, the discharge order dated 27/7/2018 is a simpliciter discharge order, and there is no element of any stigma attached to it, because you have camouflaged it. It's a cloak, my lord. The discharge order is not in the nature of punishment, as petitioner was serving on probation period and was found to be unfit for public service by the employer, that is answering respondent. Hence, the state discharge order does not cast or attach any stigma on the petitioner herein and cannot be said to be stigmatic in character. Having said all, this is the conclusion. Then, my lord, will come to page 170. 170. Paragraph 17(3) at 170. You got it? That in the present case, the petitioner is involved in a criminal case, that too for forging her answers sheets and paying bribe for fraudulently securing appointment to a public office. Such factual situation, it is most respectfully submitted that the petitioner herein has no right to public office and cannot be permitted to claim any fundamental right in this behalf. Her discharge cannot be termed as illegal or wrong in any manner whatsoever. So this is only motive. Can it be motive, my lord, when they have gone through everything and they found and they are saying we don't have right to remain in this office even for a day. The entire thing is based on these police reports. Then, my lord, will come to paragraph 75 at page 171.
Well, second paragraph I'll be referring to at page 171, paragraph 75. Others all repetition, my lord, which they have said, where we have entered by fraud, we are not entitled to remain in office for a day even. Second paragraph I'm reading at page 170. Without prejudice to the above, it is most respectfully submitted that in terms of the proviso to Article 311, whenever it is observed that it is not reasonably practicable to hold any such inquiry and be seized under Article 311(2), the said provision shall not apply. In the present case, having regard to the material which has become available during detailed and thorough investigation being carried out by Assam Police, where beneficiary of colossal fraud in the recruitment process have been found to be unfit in service in public office. It has not been reasonably practicable to hold any inquiry in such case. The proviso B to Article 311(2) squarely applies in the present case. Any contention to the contrary is unsustainable in law and deserves to be rejected. Well, the provision is there and they will say, no, it is not practicable. It is not practicable to hold inquiries. They should state why. They should give regions, region A, B, C, D, that we have not been able to hold. Otherwise, in every case, they will say it is not reasonable, practicable to hold. And what they say, my lord, let me just, at the cost of repetition, I'll start one more line from 171. Whenever it is observed, your lordship will see, whenever it is observed that it is not reasonably practicable to hold any such inquiry and be seized under Article 311(2), the said provision shall not apply. This is very simple. They will dismiss it and will say it is not reasonable, practicable to hold inquiry. You must say why. You must give reasons so that the court can go through the reasons to find out whether it was really a reason or a camouflage to pass this order. Now, my lord, paragraph, the last one I will submit, my lord, place is 172, the last paragraph, 77. 77. Contention of para 14 to 17 of the writ petition are incorrect, misconceived, and denied. The submission made herein above are respectfully reiterated. It is specifically denied that the order discharging the petitioner from service violates Article 311(2) in any manner whatsoever. My lord, I pause here for a moment. My lord, they cannot take contradictory stand. Either it is not possible to hold inquiry under 311(2). This is a case of holding an inquiry, but you say it is not practicable to hold inquiry. This is one stand. Second stand, they are saying, my lord, that the order discharging, it does not violate Article 311(2). Total confusion prevails in the humble submission. If 311(2) does not apply, why do you say that it is not reasonably practicable to hold inquiry? They should not say. Then, my lord, the next page, 2 lines I will say, submit. Without prejudice to the submissions that all cases in the present batch of writ petition are cases of securing appointment to public office by fraud, and the petitioner are not entitled to remain in these public offices, and the contention relation to these are all repetition, my lord. Only repetition, nothing else, but your lordship will just note paragraph 77 at page 171. After, my lord, stating that we got the appointment by paying bribe, by paying fraud, they say the order is innocuous. When that we accepted, my lord, my humble submission, it's a case of outright rejection of the pleading of the state. It is by way of punishment. And then, my lord, the next question which will come in is, and I'll place, my lord, a very beautiful judgment written by Justice Krishna here. But before that, your lordships are aware that even the probationers are protected by Article 311 of the Constitution. It starts right from 1958 Purushottam Lal Dhingra, then comes to Samsher Singh, and the other one, Chandra Prakash Shahi, relied upon by the learned single judge, my lord. I'll just, if your lordship permit me on this, I'll just place Samsher Singh, few paragraphs, Pani. My lord, this is stick file, if your lordship will take. Samsher Singh, page 45. Stick file. Stick
Oh,
file.
comparison 2.
Stick file. Here.
Shamsher Singh.
Samsher Singh. Samsher Singh is 7 judges or 9 judges bench?
I think it's 7 judge.
7 judges. Paragraph 62 is at page 46. The position of a probationer was
Paragraph.
paragraph 62 at page 46. You have given relevant only.
Yes.
The position of a probationer was considered by this court in Purushottam Lal Dhingra versus Union of India. Chief Justice Das, speaking for the court, said, where a person is appointed to a permanent post in government service on probation, the termination of his service during or at the end of the probation period will not ordinarily and by itself be punishment, because the government servant so appointed has no right to continue to hold such post any more than servant employed on probation by the private employer is entitled to do. Such termination does not operate as forfeiture of any right of servant to hold the post, for he has no right. Obviously, such termination cannot be dismissal or removal or reduction of rank by way of punishment. There are, however, two important observations of Chief Justice Das in Dhingra's case. One is that if a right exists under the contract or the service, government is wholly irrelevant. The other is that if the termination of service is sought to be founded on misconduct, negligence, inefficiency, or other disqualification, then it is punishment and violates Article 311 of the Constitution. The reasoning is why motive is said to be irrelevant is that it inheres in the state of mind which is not discernible. On the other hand, if the termination is founded on misconduct, it is objective and is manifest. Like here in every paragraph of the affidavit in opposition, it is manifestly stated why we were terminated. 63, I'm reading. No abstract proposition can be laid down that where the services of a probationer are terminated without saying anything more in the order of termination than the service are terminated, it can never amount to punishment in the facts and circumstances of the case. If a probationer is discharged on the ground of misconduct, inefficiency for similar reasons without proper inquiry and without his getting a reasonable opportunity of showing cause against his discharge, it may be in a given case amount to removal from service within the meaning of 311(2). Similarly, 64, actually, same thing. I need not place it. Now, my lord, I'll place. एक है, ये उसी में है।
This is 39.
Well, the next case that I'm citing is Gujarat Steel Tubes Limited versus Majdoor Sabha. (1980), Volume 2 SCC 593. Your Lordship will get at page 39 of this compilation, the stick file. Time is over, then I'll- Hmm? Hmm. I'll place few paragraphs below. Time is 1 or 1:15. Should I place it or because it's 1 already?
Okay. At 2 o'clock, we'll continue for some time.
Lordship will continue today at 2 o'clock because we were under impression it may be first half.
No, it will be first half, but for some time, if we continue and
Fair
then
enough.
better.
Also, if Lordship would just permit me, Mishra sir would be concluding today or will he be continuing tomorrow?
No, I cannot say that. I have to because well, this Gujarat steel tube will take some time.
It will take time. Gujarat Steel Tube to detail that.
Well, if your Lordship is taking up other bench, then your Lordship will take it up tomorrow at 2 o'clock.
Then we take it up tomorrow because there's a change in roster.
Yes.
Lordship tomorrow will be at 2 as the normal or will
At
Lordship take
2. At 2.
I'm grateful for
I think,
that. Leadership.
by lunchtime, we'll have clarity about tomorrow's roster.
This roster is changing every day, Lordship, because I've noticed for the last few
Some
days.
compulsions. There are some compulsions.
I'm sorry I asked Lordship. I just was curious because I've seen Lordship every day managing between multiple rosters.
Yeah, there are some compulsions.
Lordship.
And some people are workaholic.
Some are made.
Some are made.
Lordship, very often, in the other hat that I wear, the unsaid is more important than the said.
That's absolutely right. Acha, let's say the submissions of Mr. D.K. Mishra, Learned Senior Counsel, assisted by Mr. B. Prasad, Learned Counsel for the appellants in WA 98 of 2020 and WA 196 of 2020, remains inconclusive. Mr. N. Kohli, Senior Counsel, assisted by, from the last order, yes.
Same, Ankit Roy and Nimisha minutes.
As well as Mr. Along with Mr. P. Sharma, Senior Government Advocate are present. Anybody else who is present in the proceedings can give their names to the court master. We'll record their presence. List again is a parted matter on 22. Tomorrow,
Tomorrow is 23rd.
at 2 o'clock.
Tomorrow is 23rd, Lordship.
At 23rd. Tomorrow, we, sorry, at 2 o'clock when we resume, we can tell you about the time, preferably at 2, but we'll, at 2 o'clock, we'll tell you. My court master will tell you at 2 o'clock.
Grateful, Lordship.
Lord, I beg to mention item number 8, my lord. With the consent of the other side, he is for the petitioner. Here, my lord, I want to file an objection in connection with the application for condonation of delay, my lord. There is a delay of
27 days.
27 days. I want to file the objection. 3 weeks time will kindly be granted.
Okay, but this is a 24 matters. 6 months have already gone by.
My lord, what happened in this matter?
Whatever be.
My name was not shown, my lord. For a long time, I had filed a caveat. Initially, my
Okay.
yes, mine.
Okay.
First time, my name is.
Both sides are represented on the prayer made by Mr. P. Padiyal and the counsel for the respondent. This will be an IA, huh? 2 weeks time is granted to file affidavit in opposition in the matter.
Please, your lordship. I beg to mention item number 3, lordship. Mr. A. Das Gupta, senior counsel, has some personal difficulties today, lordship. So we have asked for the method for the day, right? 3.
You have informed the other side?
No.
No, don't make a mention without informing the other side. It's too bad. Renew the prayer when the matter is called. You think of yourself.
Yes, lord.
Tomorrow you are in court till 4 o'clock and then you come to know that your matter has been adjourned. Will you like it?
Actually, I don't know the other side.
Don't know is a very serious thing. Your name is there. You must find him out. You don't have caused this just for nothing. But tell me whether you like it. Just because somebody does not know you, can you take an adjournment?
Sorry, lord.
Don't do it. You are young lawyers. You must know that art. You must respect the other side also.
Yes.
Correct.
Please, your lordship. Lordship, I beg to mention in test case for listing possible.
Listing,
next week.
please make it make a request tomorrow because this is not a regular bench. This is a stopgap arrangement. Please make a request tomorrow.
May I please, your lordship, I beg to mention item number 13.
13.
13, my lord.
I'm for the respondent, your lordship.
You have taken consent of the other side?
Yes,
I'm for the
lordship.
respondent.
Okay. Both sides are represented on the prayer made by Learned Counsel for respond number 1. Matter stands adjourned today. List after 2 weeks.
Much obliged.
My lord, I have also another prayer, my lord, item number 14, 15, 17. I have also
14?
taken the consent of the other side by phone, my lord. It is also mentioned for that day, my lord.
14?
14, 15 and 17.
Okay. Same order. 14,
14,
15,
15, no?
17.
Yes, lordship.
You are respondent.
Appellant, my lord, I am.
Hmm?
I am for the appellant, my lord.
You're for appellant here
Yes, Lord.
in all these 3 cases.
Yes, lordship.
Okay, appellant.
In 14 and 15, I am for the respondent, lordship.
Okay.
And I am for the insurance company. Lordship, if possible, the matter may kindly come in the last week of June, lordship, because my senior has some difficulties. Last week of June, lordship.
15, 17, no? 14,
Last week of June, we will not keep it because
14, 15.
then there is a vacation. Then you will take adjournment on ground of vacation.
Because
Last
she'll be
week
out
and-
of station.
Hmm?
She'll be out of
No,
station.
not last week. Make it in the second week.
Lordship. After 17, lordship, if possible.
We are too close to vacation.
Yes, lordship.
Are you ready to do it on vacation? Can you can we record your undertaking that you will not take an adjournment on that day? Can we record your undertaking? See, very difficult.
But she
So
will
no,
not
no.
be available, Lordship. That's why I'm making this. appeal.
We can't have answers to everything.
Okay, Lordship.
On, if you keep it near vacation, will you give an undertaking that we will not take an adjournment on that day?
If Lordship fixes it on 17th or 18th, then I can give you undertaking.
You can give an undertaking. Okay, your name?
MSP board. Oh,
SP Sharma, Lordship.
SP Sharma. Item number?
14 and 15.
Item number 14, 15. Okay. There you had in item 14, 15. Mr. It may be mentioned that Mr. P. Sharma, Learned Counsel,
SP Sharma, Lordship.
P.
SP Sharma.
SP Sharma, Learned Counsel for the respondent, praised for a fixed date for hearing the matter on
17.
18/6/2025. Stop. He also gives an undertaking that on the said date of listing, he will not pray for an adjournment. On behalf of respondent number,
Respondent Insurance Company, Lordship.
a
National
respondent insurance company. Stop. On such undertaking, the matter stands adjourned today, list on 18/6/2025.
Deeply obliged, Lordship. Lordship, I have
Yes.
the prayer, Lordship. Item number 16, Lordship, if possible for adjourning by adjournment, Lordship. Here also, Lordship, on 18th.
You have taken consent of the other side?
Yes, Lordship, I have taken the
Okay, 16, 2 weeks.
obliged.
16.
Your Lordship, I beg to mention item number 2.
I don't know, it's not before me.
No, if convenient, your honor may fix a date, 3rd of June.
Okay. List this matter before any other bench without me, K. Surana J. Next matter, the learned counsel for the petitioner submits that there's some urgency in the matter. List on 3/6/2025.
Obliged. Well, please, Your Lordship, I beg to mention item number 5. With the consent of the other side, the matter may be passed over for the day.
5 is a transfer petition.
Yes, Your Lordship.
You are for?
Respondent, Your Lordship.
Just give me item 5. You have taken a lot of adjournment here.
Your Lordship, yes, we were supposed to file an IA, Your Lordship.
In a transfer petition, 2 years adjournment is too much. We are unable to consider your prayer for adjournment.
Your Lordship, we were supposed to file an IA. By today itself, we will file it. Your Lordship. So that may be.
No,
given.
that IA has got nothing to do with this transfer petition. What sort of IA you are proposing to file?
Your lordship. My senior is,
You see, this is a case where there is a issue of guardianship.
yes, lord,
Two minor children are involved,
lordship.
and due to the transfer petition, the trial is the hearing of the guardianship matter is stalled for more than 2 years.
Lordship.
It's not in the interest of the minors.
Your
Mother is
lordship,
seeking a transfer. Mother gives a, in this case, somewhere it is written by in the petition that the husband is, you are for the husband.
Yes, lord.
Husband is threatening her when she wants to contest the case. And that is the reason for transfer. And she has made allegations that you engage goons to threaten her.
Lordship, my senior is right now, he's not present at court. He has to leave for home due to some urgent.
No, whatever be
so-
there, but you see, why a transfer petition should be adjourned? We list it tomorrow.
Your lordship, tomorrow.
Uh, Prayer for adjournment is made on behalf of the respondent. Stop. Having noted that the proceedings of the guardianship case has been stalled for more than 2 years. A long adjournment is refused. Next para list on, make it tomorrow, 23rd.
Oh, well, sir.
Lordships. Item number 18, Lordships. That is for hearing, Lordships. I am for the appellant. On the concern of the other side. It may be adjourned till
Okay, 2 weeks. Item 18.
12 June, Lordships.
Make it 3 weeks then. Okay.
My pleasure, Lordship. My lord, item number 19, my lord. In item number 19, I am for the, my lord, appellant side, my lord. My lord, a learned advocate, my lord, for the insurance company, he has requested me to take adjournment, my lord. He is not interested to do this case in today, my lord. He is out of station, my lord. My lord, may I pray, my lord, let it be come after 3 weeks, a fixed date may be given, my lord.
We are not giving a fixed date. Making it after 2 weeks. Both sides are represented. Mr. A. Manaf, learned counsel for the petitioner, submits that he has received request from the learned counsel for the insurance for an adjournment. So prayer is allowed. Matter stands adjourned today, list after 2 weeks.
Obliged.
Supplementary list item 25 for withdrawal.
I have instruction for withdrawal.
Okay. Your name?
AK Hendik, Lordship.
AK?
Hendik.
KK Hendik. Okay. Upon instructions, Mr. KK Hendik, learned counsel for the applicant. Is for allowing the applicant to withdraw this application. He need to look at the application. Prayer is allowed. The matter stands dismissed on withdrawal.
Obliged.
Just add, there's no representation from the respondent. And then you also say, just also add there, consequently, the unregistered MAT appeal also stands dismissed.
Daily list item 1 motion BA.
Wait, yes, Mr. Manan. Yes. In a civil bench, we start with a bail.
Yes, this is a, actually, it's a rejected by your lordship earlier.
Okay, so
It's
we'll
a
have
four
to,
eighty-three BNSS.
okay, we'll have to call for the.
Yes, call for this is a short
and-
dated case, your lordship will call for the scan copy.
And no, just tell us,
Hmm.
normally when I dispose of a bail application, we call for the scan copies earlier.
Lordship.
So it will be available in the earlier record, will it be available?
Yes, yes, because this is a charge sheeted case already. The matter is pending before the session judge coming up.
No,
I mean,
what I'm asking is that,
Oh.
is the scan copy called in the earlier case? Is it available? Do you remember it?
it was available at that
It's
time.
available.
Now here, your lordship, I have actually alleged two specific grounds of violation of fundamental rights. Under
Grounds of
article-
arrest.
uh,
Grounds of arrest.
As well as Article 21.
Okay,
Let him get the scan copy.
okay. Had Mr. Y.S. Manan, then counsel for the petitioner. And Mr.
Agent,
K. Jain, learned counsel for the respondent. Next para.
on behalf of Mr. Esikia,
On behalf of
Mr. Esikia,
standing counsel for NCB. Next para. The it appears that the scanned copy of the trial court record would be available in BA 4258 of 2023, which was disposed of by order dated 26/6/2024. So accordingly, court is inclined to call for the records of the said BA 4258 of 2023. Next para. The registry shall also call for the scanned copy of the evidence, if any, recorded after 26/6/2024.
Please, your
From the court of Learned,
Learned Session Judge Kamrup
no,
Amin.
special judge. Special judge, special judge, Kamrup Amin Gaon.
No, this is Session Judge in Amin.
Lordship, session judge.
Session Judge Amin.
Okay, sessions judge. Amin Gaon. Post of objection, if any, by the respondent may be filed within the next date of listing. List when? After 10 days?
Lordship. Lordship, second bail application was rejected on 20/11/24 by your lordship.
Which page?
Page
That is
44,
page-
Annexure 5.
Okay, okay.
It is 2011-20.
Okay, then it will be a different date. Page number 40,
Page
44.
44.
44. Okay, then this
Bail-
case number would be BA 2732 of 2024. Date of disposal is 2011-2024. So records will be after 2011-2024. Evidence, if any, recorded after 2011-2024.
Lordship. Much of
Lordship is putting a fixed date.
after 10 days.
After 2 weeks.
2 weeks.
No, Lordship may fix a date because the bail matter.
Okay. Give a date after 10 days, then within 10 to 14 days.
June. Lordship.
Since Amin Gaon, can it be a little bit earlier? here?
It won't come. It takes some time to have the scanned copies sent and received it here. And on top of that,
Yes.
I'm a bit handicapped because of hearing
That-
which is going on in the
Yeah.
division bench.
That I understand. But
That's,
since being a bail matter. that's
we
why I'm
understand,
saying,
we understand.
Can it be on third? If possible?
No, third is Tuesday. Fourth then, fourth.
Lordship.
Much.
Much of.
Supplementary item 26 for motion.
This is an application by the wife in a guardianship case, my lord. The case was instituted, my lord, this sole respondent and.
Why you wanting a
petitioner.
transfer?
My lord, there are two grounds. One, of course, is my lord, personal difficulty in attending matters at Silchar, while the wife and the child are both residing permanently in Hailakandi. It takes 1.5 hours. And secondly, my lord, nobody probably noticed that Silchar, section 9(1), my lord, of the Guardian and Ward Act, under which the case is filed, it specifically says that, my lord, the case has to
Where
be
the child
instituted
resides.
when the child resides, my lord. The child's
Sir.
convenience has to be paramount here, my lord. Your lordship has a look, my lord. Nobody noticed it probably earlier, my lord. It has to, if it goes to the proper court jurisdiction, my lord, it would be better for everybody,
We don't know, but the age of the child,
my lord.
he would always love to travel.
Difficult.
He's a
my lord.
7-year-old kid. He will always love to travel. Have you asked the child?
That has to be, my lord, ascertained, my lord. That-
Normally, a child of 7 years would love to travel.
But
He's
then,
not interested
my lord,
where.
traveling into a court environment all of a
No,
sudden,
we don't
my lord,
know, but as a
that
kid,
is also sensitive, my lord.
as a kid, I used to love
I
traveling.
understand that. I understand that.
Okay. Heard. Mr. B. Pathak, the counsel for the petitioner. Next para. The petitioner, who is the estranged wife of the respondent, is seeking transfer of the guardianship case from the court of the net principal judge, family court, Kachar. Guardianship case being FC within bracket G, bracket close, case number 15 of 2023, from the court of principal judge, family court, Kachar, Silchar, to the court of district
There's
judge,
no family court at Hailakandi, so this is the district. judge.
district judge from Hailakandi. Next, the learned counsel for the petitioner submits that as per the provisions of section 9 of the Guardians and Wards Act, correct?
My lord.
Guardians and Wards
That's
Act,
it.
comma, a guardianship case is required to be instituted in a place where the child ordinarily resides. So it is submitted that the child is presently residing with her, with the petitioner since last 1.5 months, one year,
8 years, my lord. All along, the child has been with the mother.
8 years,
My lord.
last 8 years. The mother since last 8 years in Hailakandi. Next, issue notice returnable on so and so. Give a date after 4 weeks.
My lord.
The petitioner shall take steps for service of notice on the respondent by registered post with AD, as well as by usual process. Next para. Till the next returnable date, the further proceedings of FC within bracket G, bracket close, case number 15 of 2023 shall remain state. Next, however, the petitioner shall produce a certified copy of this order along with the petition before the
Tomorrow
learned
is the date. Only
family
we
court to
can get
bring
an
the order to
online
the
copy of
notice of the said learned court.
Tomorrow is the date before my lord Silchar. So we'll only get an online copy, my lord, if it's uploaded. Certified copy might not be visible tomorrow.
We don't know. If it is online, then certified copy is also available.
My lord.
But to make the orders effective, you'll have
I
to
know, I
communicate.
know. We have to produce. We have to produce.
20 June.
Obliged. Deployed.
You're returning back your document.
Item 3.
Oh, you are praying for an adjournment.
Yes, Lord.
Yes. Okay.
If possible.
Both sides are represented on the prayer made by learned counsel for the appellant. The matter stands adjourned today. List on
5th of June.
oh, okay, 6/6/2025. Yes, item 4.
Your Lordship, we were directed to take paper publication upon R5 and R6, and we have also filed our affidavit. It's on record, Your Lordship.
So item 7 to be the proxy. 7.
And not only.
You have a photocopy of this newspaper?
Yes, Your Lordship.
Please produce it because this is, you have,
Your Lordship,
uh,
is there in the case record also, in the court records?
it's available.
Yes, Your Lordship, we took
Yeah.
steps in Assam Tribune, Your Lordship.
Oh, that you have stitched it up. We can't open it.
I do not have the Xerox as of now, Your Lordship.
Give a copy.
Okay.
But as per earlier order, my lord, notice already been served, my lord, deemed to be served, my lord, on respondent number 5 and 6, my lord. My lord, only chance, one chance, more chance has been given, my lord. In fact, my lord, in before learned tribunal, they did not appear, my lord. They did not contest the case, my lord. My lord, record has come, my lord. May I pray, my lord, it may be fixed for hearing, my lord.
This one, your name?
My lord.
A. Biani.
Ms. A. Biani, and counsel for the appellant, was referred to the affidavit of substituted service. It's filed on 13/6, 28/1/2025. Indicating that notice to the
Respondent number 5 and 6.
respondent number 5.
5 and 6.
6, owner and driver of the vehicle. Your Lordship.
5 and 6 were served in a substituted manner by newspaper publication of notice in the Assam Tribune dated 17/12/2024, wherein the date of appearance is indicated as 7/1/2025. What's wrong? Accordingly, notice is deemed to be duly served on the respondent numbers 5 and 6. So none appears on call for respondent numbers 5 and 6. Stop. However, Mr. A. Manaf and the counsel for the respondent numbers 1 to 4 is present. Is the records of the tribunal is received, let the matter be listed for hearing. After 2 weeks on a date to be fixed by the office. You
Much
take back,
appreciated.
please.
I love.
You're returning your copy.
Item 6 for orders.
May I please, Lord?
Yes, Mr. Mazumdar.
My lord, this is an injunction appeal under order for.
You still get time for that.
My lord?
You still get time for that.
One has to manage. My lord, this is an injunction appeal. The plaintiff is the daughter and contesting defendant, who is now the appellant before lordship, is the mother. My lord, what has happened, my lord? I just give the background without going to the papers, my lord. Mother is the owner of Schedule A land, measuring 4 cutters.
Mother is respondent here.
My lord, appellant.
Mother is
before
appellant.
lordship. Yes, defendant appellant.
She is owner of?
Owner of 4 cutters of land. These are all admitted position, madam.
Yes.
And then Schedule 2 land measuring 4 kata 5 chatters was purchased by father, and after expiry of the father, mother and her 4 children, my lord, including the
2 kata
plaintiff.
4 chatak.
Yes, my lord. 4 kata 15 chatak 5 gonda. This was purchased by father.
Yes.
Now, father has expired. 5 persons, 4 children and mother have inherited, and this Schedule 2 landman. All have executed, all the legal heirs of father, that means other sons, 2 sons and a daughter, have sold their share of Schedule 2 land in favor of mother.
2 children.
4 men.
All 4.
Yes. No. 3 of them. I'm sorry, 4 of them, excluding plaintiff, who is also a daughter. He had 3 daughters, 2 sons.
4 children relinquished in favor of mother.
Yes. They have executed sale deed, my lord.
Sale deed.
Sale deed. Registered sale deed.
Okay.
Now, daughter has her share. But somehow, my lord, the configuration of the land is such that she will not have any exit path. Now, permission for construction was taken in 2012. And going by the averment in the plain, 2015, they have completed the construction. Meaning thereby, my lord, this first floor, second floor, they have completed. Now, this suit was filed in 2023.
Yes.
Praying for a lordship is looking to some provisions.
Yes. Yes, please proceed. I am doing multitasking.
Yes. My lord, the plaintiff has filed the suit in 2023, saying that she praying for a decree that with regard to Schedule 1 land, which admittedly was purchased by the plaintiff, the defendant number 1, that is mother, her ejmali right should be declared. So far as the defendant number Schedule 2 land is concerned, there also she says that it is ejmali and ejmali right should be declared. And then she has made a Schedule 3, that is her main grievance and cause of action, that a path measuring 32 feet in length and 6 feet in breadth should be declared as ejmali, because this she requires for ingress and egress to her land, which is bounded on the 3 sides by 3 walls of different patadars, and on one side mother's land. Mother has constructed 2-story building is already there. Now 2023, my lord, 2024, an injunction order is passed at her instance, preventing me from making further construction over the. I'll show you a photograph. Her grievance is her land is separate, her land is intact, we are not touching her land. And others have already sold it. Others,
She is your daughter.
Uh,
You can give her, offer her the path. Yes.
absolutely, my lord. But she is slightly violent type of lady. The other daughter, she with a feast, my lord.
What is wrong with that? She needs a path.
My lord, her part she has. She wants to prevent the
No,
construction.
no. Path. I am on path.
Path also, my lord. She has obtained an injunction preventing me from raising my construction.
No, otherwise, you are not giving the path. And the path which you are showing in this photograph
My lord.
has encroached over the path. Rightly, an injunction is granted.
No, injunction is granted preventing me from making further construction. Over the path, if some injunction order is there, matter would have been different. She should have asked for a mandatory injunction.
This is the house. This is your
Yes,
construction.
that house, yes, under
This is your construction.
Yes, my lord.
And it is encroaching the what you call the cantilever is encroaching the path.
No, she is not on that. Her case is that her Ejmali right over the Schedule 1 land, Ejmali right over Schedule 2 land, where others have already sold out their share by a registered sale deed. Those should be declared. And so far as Lordship, may kindly have a look at the plain manual, page 14. What is the prayer?
14.
Page 14.
Where is the construction permission?
Construction permission, well, we have mentioned that you will also will find in the written statement manner, page 26. Permission.
How much to read?
My document is not there, but then averment is there.
How much to read?
That I have to check, madam. Permission. And I can find out from
No,
that.
it's okay. Not required.
Page 26, I have mentioned that 2026, the 12 permission was granted. Now, prayer, your lordship will kindly see here at page 14.
14.
My lord.
Yes.
First is on top, my lord, para 17A. For declaration of Ejmali right, title and interest of plaintiff over suit land and house and pathway mentioned in Schedule 1, 2 and 3. Then second prayer, for confirmation of Ejmali position of plaintiff over the land and houses and pathway as mentioned in Schedule 1, 2 and 3, and then permanent injunction, etc. With this, my lord, kind of prayer in the suit, my lord, she files the application for temporary injunction, which your lordship will find.
Yeah, just a moment.
My lord.
Where is your written statement?
Well, page 16.
Page
16. 1 6. My lord. Real facts, my lord, I have stated from page 24 onwards.
Please tell me,
my lord.
what is wrong in that claim of share by by the daughter,
My lord.
claiming it to be Ajmali? What is wrong in that prayer, according to you?
Yes. My lord, so far as schedule 1 is concerned, admittedly it was purchased by different number 1.
Correct.
So far as the different number 2 is concerned, my lord, sorry, schedule 2 is concerned,
Yes.
other legal heirs have sold out their share of the land. She has got her land separately, that she is not disputing, that I have not bought my land. And I have specifically made an averment that other legal heirs of my husband have sold out their share to me. And I am in, my lordship will kindly see the way I have made the statement, I am within definite boundaries and mutation also has been done. And after the construction was completed, she has visited the housewarming ceremony also.
You see, so far as I understand,
My lord.
maybe I am a little bit out of touch, but so far as I understand, if the father died,
My lord.
the land would be inherited by the all legal heirs,
Yes.
including the daughter.
Yes,
And therefore, the right accrues on each part of the land.
yes.
Now, if that is so, then notwithstanding the sale by the sons to the mother, the right of partition will still be there.
She is not paying for partition here. Your lordship is absolutely correct. I understand what your lordship is indicating. If I have purchased from one of the co-sharers, then I must sue for a
She's
separate position.
she's otherwise brilliant, with Mr. Chakravarti behind him.
Yes, yes.
He is not asking for partition. She said that she has an Ajmali right,
Yes.
and therefore, if required, you go for partition. She doesn't want to.
Yes, but that's
He
absolutely
charges.
correct.
He charges too much. He doesn't want to go to him.
But absolutely correct. But here is a case where when I say that I am within specific boundary, if the dispute the matter is different, I am within specific boundary. She is possessing her part of the land that she is suppressing.
No, that will be against. You'll have to again convince me,
My lord.
because my concept may be wrong,
Right.
but it says that if there is a co-sharer.
Your lordship is correct. I
And-
must come forward and say that
No,
please
not that.
separate my share.
No, no. The proposition which I am trying to recollect
My lord.
is that, or thinking aloud,
Right.
is that a co-sharer
My lord.
will hold the land for other sharers as a in benefit of others. So he doesn't, even if you have a definite share, that is in interest of others.
My lord, there are, your lordship is correct. Legally, that is correct. But here we are, my lord, considering the question of grant of injunction. My lord, she has suppressed the fact that others have sold out their part to me. That is
Achha,
total suppression.
notwithstanding whatever has happened,
My lord.
under order 32 rule A,
My lord.
can you ask for a mediation between these parties? If it doesn't happen within 7 to 10 days, then we take up the matter on merit.
Yes, my lord. I also understand it's between mother and daughter. We
Yes.
should always, all of us should always try for that, my lord.
You, will the parties be doing it here or there at Silchar?
And that, so far as our client is concerned, probably she's a old lady. We can find out. Possibly they can come. It is better that they come
After some time, you can tell us.
Yes.
We are here till 4:30. You can tell
Yes,
us.
sir. Lordship, give me just 5 minutes. We'll find out my land.
You have the time till the rising. You can definitely take time and find it out.
Yes,
You also try to find out.
My lord, in so far as the possibility of mediation is concerned, that in so far my instruction goes, my lord, that was endeavored. There was a sitting.
No. You will have to convince them to have a sitting.
Yeah.
It's a. There's a simple way. Can I say it?
Right? There is a very simple way. What my learned.
No, let me tell you the simple way. The simple way is that you tell your clients that the judge is very unpredictable. Once he has requested, better do it. Otherwise, he's unpredictable.
And if some sort of a compromise is arrived at, my lord, the entire litigation can be
Tough.
Yes.
So lay the blame on us.
Yeah.
It can be done, my lord.
No, do it. Not can be done. To convince them the judge is unpredictable.
Lordship.
After some time, come back.
Takes
Speak to them.
my lord.
Yes. 5 minutes, man. I'll just get back to you. Lord.
after some time. Yes, next.
Item 7.
May please, Your Lordship. I'm for the respondent, Your Lordship.
Is this IA for continuation or delay?
IA filed for injunction, Your Lordship,
IA for.
by the appellant separate. I have filed my objection, Your Lordship.
Where is the judge? Where is the judgment and decree?
It is in the
Memo appeal.
memo of appeal, Your Lordship.
Where is that?
Memo of appeal, it is the appellate decree judgment, Your Lordship. It starts from,
Who is the plaintiff? You or the appellant?
I am the defendant.
You are the defendant.
Yes, Your Lordship. The suit was dismissed. I preferred appeal. Appeal was allowed. The second appeal filed by the plaintiff.
What is the prayer in the plaint?
Page 13, Your Lordship. A decree for declaration of plaintiff's right on the suit land and title, a decree for possession of the suit land. Recovery of possession is there.
See, is the deed of donation available? No.
Deed of donation, Lordship, it was exhibited, Your Lordship, it was exhibited. Exhibit 5. It is page 31, Your Lordship. Exhibits by the plaintiffs.
The appeal is by appellant. You are the respondent.
I am the respondent.
There's no representation from the applicant. However, Mr. A. Shomla, and counsel for the respondent is present. So for ensuring justice, the matter stands adjourned today. Just after 2 weeks on a date to be fixed by the registry. Adjourning the matter.
Oblige, your lordship.
Daily list item 9.
May I please lost, I am, in this case, my lord, I am for the respondent number 2. So my lord, they filed a petition for a continuation of delay. In this case also I filed a counter affidavit, denying this delay.
How much days delay?
My lord,
How much day delay?
my lord, as per the petition, they are not clearly explained day-to-day delay, my lord. It is not explained sufficient causes prevented for filing this appeal in time, my lord. My lord, as per my lord, the date of judgment, the delay is 2,571 days. Judgment was passed in
Just a minute, you are for the appellant, insurance.
My lord, I am for the respondent number 2.
Let him say.
Yes, Lordship. Lordship, this delay continuation petition, Lordship, there is some defects. Lordship, initially I had said that there is a delay of 2465 from the date of the judgment, but the Honorable Registry of the Honorable Court, Lordship, you corrected it to 80 days, but then one defect still remain. In the 6th, 7th line, instead of 91, I should have written 80. I think I need to correct this part also. As you may see, initially I had corrected as.
Delay of 91 days.
91 days, no, sir.
Registry corrected it to 80 days.
80 days. So that in the next third line, Lordship, I need to, after have corrected it to 80, it remained as 91. Lordship.
Okay, and Mrs. Chakravarti, what is your objection?
My objection was that, my lord, date of the judgment was on 15/7/2015. And from the date of the judgment, 15/7/2015, there's a delay of 7 years, 16 days. Means 2,571 days. And for the, from
2,571 days.
from the date of the judgment passed by the Met Tribunal, my lord. So, my lord, again, they filed the review petition, which was disposed on 27/2022 after 180 days. They filed this review petition after expiry of the 3 months from the date of the judgment passed by the tribunal. And the judgment has been passed in the 2027/2002. That is also after expiry of the 7 years. From the review order, my lord, it is reflected that after 7 years they have entertained this, passed this order in review petition, my lord. After condoning the delay, they filed this review petition with a petition for continuation of delay, which was considered, and the review was rejected.
Which page is the order in review?
Yes, my lord, in my memo appeal, my lord, annexure 2, my lord.
Memo appeal. Does it?
Memo appeal. At page 18, my lord, in memo appeal.
Just a moment.
27/2022.
Just a moment.
Memo appeal. Memo appeal. Given it in a memo of appeal, Lordship, page 18. Page number 18, Lordship. You got it. The tribunal had condoned the delay, but then dismissed the review petition.
But then your interim interrogatory application will be defective.
Yes,
This
madam.
is, Chakravarti is right. You'll have to explain the delay of 2571 days and then claim period spent in review to be an exclusion.
Yes, madam.
Lordship.
That is an explanation, but the delay.
Lordship, in fact, prepared it that way. Registry correct. I saw it to depend that there is a delay of 24, it was my initial 2465 days in filing this appeal. But from the date of the review was, there is a delay of 91 days. That was my original Lordship PA. So that,
You originally claimed 2571 days
yes, Lordship.
in the appeal,
Yes, Lordship.
in the condemnation application.
Yes, Lordship.
Just a moment.
Then that was Lordship
just a-
corrected. by the-
Just a moment.
But I'll file the recording, Lordship, because. Hmm?
My lord, if we count
just
from the
a-
date of the
just-
review order, my lord.
Just a moment. Give me some time. Please hand over your copy. I can't read this dates here. Give me a copy where the date is reflected.
Yes, sir. So in fact, today there's another IA filed by her, so I was thinking of making a prayer today for correcting this mention. I thought this will be the IA. What has come today is 1433 of 24.
Yes, madam.
So as while.
Are you going to reply?
Huh? No, no, pen.
Mrs. Chakravarti will permit him to correct this because this is not his mistake. He has given this 2465. Registry did that calculation and arrived at a conclusion that it was 80 days. And this 80 days is reported in the memo of appeal. And therefore, this correction was made by Mr. Goswami. This does not appear to be his fault. It's a mistake which has happened, but not attributed to him. There's a calculation made here. You go through it. Etu Dasji. So this is the calculation done by the registry and therefore this correction is made.
Yes,
In his
madam.
original petition, he says 2465.
Yes, madam.
So 2465 was, he presented it correctly. According to you, it is 2571. But according to Mr. Goswami, it is 2465.
Yes.
So whatever be, but the registry did the correction, calculating from 22, it says 80 days delay and therefore this correction in the cost title. So this is not attributed to him. Part of registry is also at fault. We permit him to correct it.
My lord.
Permit him to correct it.
Yes, my lord. My lord, in this matter, I have filed another IA, my lord, 1433 of 2024 for striking out me from this, the appeal, my lord. My lord, in this appeal, once this appeal was filed before the tribunal, I was made party, but I didn't enter in this case, my lord, even driver also not.
Who are you?
I am the respondent number 2.
Owner of the vehicle.
Owner of
I
the
am
vehicle.
the
No,
owner of the vehicle.
you can't be released.
So, my lord, I was not directed on the insurance company is directed to make payment of the compensation amount. I was not directed because my driver with very
Can you give you file an affidavit saying that you will not be aggrieved if we pass an order to the insurance to make the payment and recover it from you?
no, no, my lord. Since
No,
I
see, what is the difficulty? We are allowing our application. We just want a guarantee. Give a guarantee. What happens tomorrow if I am I am of the view that in this case, the insurance will make the payment and recover it from the owner?
no,
Then
my
what happens? We exonerate you.
no, my lord. And my vehicle was insured.
You see,
under
you have
insurance
100 good
company.
reasons, Mrs. Chakravarti. I am not disputing whatever you are saying.
Yes, my-
Everything correct, 100% right. And we are in the verge of allowing your application. Give an undertaking.
So, but in the review petition also, I have not made party.
It will be that. We have not yet come on the merit. Now we are only on the interrogatory application.
Yes,
Once the
sir.
delay is controlled, we will hear on merit.
Bless my lord, your lordship.
Please tell us if you can enter into the merit right now. We can't enter into the merit whether you are party or not is not a consideration right now.
My lord, yes, my lord, already I explained, my lord, in my petition, my lord, why
We
I
agree.
should be party.
We agree. We are in verge of allowing your application. File an affidavit tomorrow. We allow your application. Uh, 1542. That Mr. R. Goswami and counsel for the applicant as well as Mrs. U. Chakravarti, learned counsel for respondent number 2. Next paragraph. The learned counsel for the applicant has demonstrated that when this interrogatory application was filed, he had explained the delay of 2465 days. Stop. However, while the registry made the calculation of delay, note has been made in the filing slip of the connected appeal where the delay was calculated at 80 days. Stop. Resultantly, the applicant made correction in this interlocutory application to make the delay in consonance with 80 days, as reported by the registry. Full stop. Next paragraph. It is seen that the appeal is directed against the order and award dated 14/7/2015 passed by the learned tribunal, learned MACT.
My lord, 15/7, man. I'm sorry.
15/7, that's what you
Yes.
said. 15/7, no? 15/7. Was learned tribunal. So, however, review was preferred and the order of review were passed on 22/7/2022. Full stop. Next paragraph. Therefore, it primarily appears that the delay of the explanation of delay would be from would be referable to 15/7/2015, when the award was passed. Most of the time spent in agitating the review petition would be an explanation for the delay. Next paragraph. Resultantly, the court permits the learned counsel for the applicant to amend the interlocutory application in such manner as the applicant may be so advised. In order to remove doubts, comma, if any, with multiple erasures, comma, the court permits the amended application to be filed.
Yes.
Within a period of 2 weeks from today, within a period of within a period of 15 days from the date of the order. List after 15 days. You can give a date, Mr. Coordination, after 15 days, give a date, this one. Now this IA 1433.
Yeah.
Here you say, I heard Mrs. M. Chakravarti, counsel for the applicant, as well as Mr. R. Goswami, learned counsel for the respondent. Yes, here, what do you have to say?
Lordship, in fact, there's no
Fine.
policy. That's the reason why a review application was filed. In this case, she can't be exonerated or.
So you want to file an objection? No.
I'll file one.
Okay. Praise for his, Mr. The learned counsel for the respondent, praise for his granted 2 weeks time to file objection in the matter. Next, list on, so and so, same date.
9th of June.
Bless you.
It will ready to go.
Time being item 6.
Yes.
With the weapon your lordship has provided, I've been able to convince, he has talked to the client, the lady has ultimately agreed to come on Thursday.
Yes.
Lord, in a case of this nature,
Now
unless
tell
there
us,
is-
since I'm not very well acquainted with the names of mediator counsel in Silchar, can you suggest a good name?
it will be in Silchar or here in Guwahati.
No, let it be there. You
Then-
said that she's aged lady.
She can come here. I think intervention of this court and particularly your lordship, without this is not going to be settled, because unless the parties are compelled to shed the arrogance and ego based on which the suit is pending now, because rights are clear. In spite of that, the litigation is going on. I am not on the right, my client's victory or
You
anything.
tell us date.
Thursday, my lord.
Yes.
I have conveyed. Let them come here, lordship will intervene, the matter will be settled, I think.
Thursday.
Thursday.
Thursday is 29th.
29th. 29th of May.
Yes, yes, please.
Okay. But you'll have to communicate the downloaded copy of the order to your parties.
Yes, that will that. Very good.
Okay. Had Mr. D. Mazumdar, Learned Senior Counsel, assisted by Mr.
D. Mazumdar.
D. Mazumdar. Okay. Legacy continues. Good. The counsel for the applicant, as well as Mr. D. Chakravarti, Learned Counsel for the respondent.
Sole response.
So, respondent. Next paragraph. This being a dispute between the mother and daughter, comma, the court is inclined to direct the parties to be present for attempt of to be present for mediation. Full stop. Next paragraph. Although initial reservation was expressed, comma, but at the insistence of the court, comma, the parties have conveyed to their respective learned counsel of their willingness to participate in the mediation process. Next paragraph. Accordingly, the court is inclined to send the matter for mediation in the Guwahati High Court Mediation Center on 9/5/2025 at 11 a.m. Stop. Did this order be brought to the notice of the Guwahati High Court Legal Mediation Center so as to arrange for mediation to be held at the appointed date and time. So the the court is inclined to appoint list as a mediator. Mediator list as a leader. Is inclined to appoint Ms. B. Saikia, Baharun Saikia,
Yes, I was
Leonard-
thinking about
Leonard
Barun speaking.
mediator to mediate in the matter. Next paragraph, the issues of individual notice to the parties is dispensed with. So as both sides are represented by the learned counsel, they would communicate a downloaded copy of this order to the parties to bring the order to their notice to appear in the mediation process on the appointed date and time. Next paragraph. How much time for mediation?
On the
They can stay over for
Couple of days.
Thursday and
Yes.
Thursday and Friday.
Yes.
Yes, that will be continued.
Mediation. So the mediation may continue on the next working day. If for some reason the mediation is not concluded on 29/5/2025. Next paragraph. Awaiting, let the report of mediation be placed before the court on 4th of June.
Yes.
Yes.
4th of June, next paragraph. This is the matter on 4/6/2025. Okay. That will continue.
Yes.
My lord. Deeply.
Obliged.
Item 10.
Mr. Datta, Mr. Datta, at our times when we were youngsters, we had a movie, Guns of Neveron. The times we use it here.
Yes.
Yes, item 10.
Lordship, the parties have come to a compromise settlement, Lordship. This is the copy.
It will be.
So we have instruction to withdraw it.
Okay. Heard
SP Sharma.
Mr. SP Sharma and counsel for the applicant. Next, the learned counsel for the applicant has submitted that during the pendency of this interlocutory application, which was filed under Section 5 of the Limitation Act, the appellant, i.e. the National Insurance
New India, Lordship.
New India Assurance Company Limited, as well as the workmen, namely Mofizul Islam. There are one or two people.
One people, Lordship.
Mofizul Islam, within bracket respondent number 1, have arrived at a negotiated settlement of the entire claim of the respondent number 1 Next para, it is submitted that he has received instructions from the New India Assurance Company Limited, the applicant, that in terms of the settlement, the applicant has agreed to withdraw this interlocutory application. Next paragraph. Photocopy of the said instructions is written on record. Rest of this interlocutory application stands dismissed on withdrawal. Next paragraph. Resultantly, comma, the unnumbered, the connected unnumbered MFA, which is filed under filing number MFA oblique 11770 oblique 2023 stands dismissed.
Obliged.
Item 11.
Lordship.
Yes.
I'm for the appellants.
What is this IA4?
Appellants as a applicant, we file an application under order 41 rule 27 in second appeal. That was substantially heard on 5/5/2024-25. I don't know why it was fixed to the either series for order. That was heard by another court on 5/5.
No, this was directed to be listed on 22/5.
Lordship.
Okay, we'll send it to the same bench. You said substantially heard.
Lord, it was substantially heard.
So they,
In the order, it is not reflected.
Reflected.
no, it only says heard learned counsel Mr. B.K. Bhagawati and Mr. P.C. Dey.
Lordship, my lord.
List the matter on 22/5. So we send it for the listing on the same bench. Okay. Mr. B.K. Bhagawati, learned counsel for the applicant, as well as Mr. P.C. Dey, learned counsel for the respondent, have submitted that the matter was substantially heard by another honorable bench, within bracket, Justice Susmita Pankhaun, on 5/5/2025. And the matter was ordered to be listed on 22/5/2025. Next para, accordingly, let the matter be listed before the appropriate bench within bracket Justice Smith of County. Make it next Monday. Monday, list on, give a date, Monday, 28.
My lord, maybe
26.
yes, Monday.
26.
Oh, 26th, I'm sorry.
Lordship.
26th.
Item 12 for hearing.
The decree of reversal.
Where is the plaint?
Plain to your lordship will find.
And what is the substantial question of law?
Yes, substantial question of law, your lordship will find at page 6. I'll rely on C, my lord. At page 6, there are 3 substantial question of law. Apart from A, B, the mainly on C, my lord.
The suit was allowed or decreed?
It was dismissed, my lord.
This was dismissed.
Appeal was allowed, against that we have come before lordship.
Do you have a copy of the cross-examination in English typed out? No.
Yes.
DW1?
It is there. It is in English.
No, DW1, cross-examination is in Bengali. I
DW1
think.
is in Bengali.
Assamese come Bengali.
Bengali.
This is something I can't read.
Yes, yes. We can get it done, my lord.
Because here one of the issues, I was just trying to cursorily go through it, is that the order of reversal was made because the Civil Judge Senior Division, he found that the evidence of DW2 was not reliable, DW1 was not reliable.
In fact, my lord, what happened here? The DW, the cross-examination, the entire evidence of DW2 was never considered by the appellate forum. Otherwise, this,
But DW1 also was discarded.
yes.
DW.
No, the plaintiff could not establish their case at all, my lord.
No, we don't know because there's two things coming up. Number one, one point is that the order of reversal when it was made, the grievance was that the burden of proof was put up on the defendant. That is what the substantial question of number one is.
Yes.
So if the proof is on DW1, what is the evidence of DW1? That is what I wanted to see. That's
Yes.
the
DW1, the chief your lordship will find in English, but then cross-examination is in Bengali.
is in Assamese come Bengali. I could not read. I tried to, but I could not.
The language, the writing is not up to the mark.
No, I won't comment because my handwriting is equally bad.
Even for us also, it is very.
But here
Even I tried to read. It was very difficult.
Get it tested.
please get it done because I will ask the evidence is DW1. Which are the other evidence which you require to read? You'll ask the. Because if you can give us a translated copy, we'll get it vetted through our translation section.
Yes.
It'll be very fast then.
Yes.
Yeah, they are expert. DW1. My lord, let us do it, my lord, within a week.
DW2 is also in.
Yes, we will get it. It's a small one.
Hmm.
That will be also necessary, madam. Ultimately for the adjudication by your lordship.
How much time?
1
You
week
can
will
you can
do.
share it. You see, one or two you can do it. One or two Mr. Zata can do it.
Yes.
It'll be-
Yes. Yes, madam.
That we shall share with now.
My lord.
Okay.
Madam.
So when do we fix it next?
Immediately as your lordship wishes.
No, you tell us. It's convenience of both of you.
Yes. After 2 weeks.
After 10 days to
2 weeks. After 6.
on the 5th June, my lord.
Oh,
So, yeah. 13 or 12. But 10th can be.
No,
okay.
no, you see, what I am proposing is, once you give it to us,
Yes,
because of the orders of the court, it will go to the translation section. They will just look into it.
Yes.
So they will need at least 3-4 days time to look into it.
Right.
So once you give it by 5th,
yes.
then say around 10th, we can fix the matter.
Right.
Yes.
So it depends on when you can give it to our section so that they can send it to the, or
Tomorrow? Tomorrow?
Day after tomorrow. Day after tomorrow will. No. Definitely. We'll do it. No problem.
oh no, it's okay. That means we'll take it, you can give it to us by Tuesday.
By Tuesday. By Tuesday.
Okay.
Tuesday.
So Tuesday is 27th.
By
So then it goes to the section. They will take 2 or 3 days time to look into it, and we can have it in the first week of June.
Yes.
You choose a date on first week of June.
On 9th or 10th, any day, my lord. 10th will be Tuesday.
10th.
Will be better.
Okay.
10.
10th also.
Mr. Datta, convenient to you?
Yes.
And Mr. S. Datta, and Senior Counsel, assisted by Mr. K. Hussain. K. Uddin, Learned Counsel for the appellant, as well as Mr. A. Chaudhary, Learned Counsel for the respondent. You are appearing for all?
Yes.
Next para. The matter could not be heard today as the cross examination of the
DW2 and 1
and what about PWs? They are
only 2 PW value. We will get it done also.
no, but PW I did not check PW.
This is in English.
Cross in English.
Yes.
Both English and PW1 is English.
Just check up. I did not.
Yes, sir. PW2. Two is also English. We'll get
In
it
English,
right.
okay.
Yes.
The cross examination of DW1 and DW2 are in vernacular, for which translation is required for the court peruse the same. Next para. The learned instructing counsel for the appellant and the learned counsel for the respondent have offered to make an English translation from vernacular to stop. Upon doing so, the translated copy shall be handed over to the AOJ, civil appeal section. Second appeal? Civil appeal section. Full stop. On receipt of the same, the AOJ, civil appeal section said, send it to the translation section for their vetting. Full stop. Under this would do so by 27th. By 27/5/2025. Everything. Next para. The translation section shall do the needful for vetting the translation of the cross examination of DW1 and 2. Next para. The matter shall thereafter be listed for hearing on 10/6/2025.
Can it be marked as parted? Lordship, can it mark it as parted?
No.
Actually, your lordship gone so.
No.
It will be easier for us.
No,
Yes,
no.
my lord.
You see, there's nothing here.
I was happy to make an argument here.
No.
Yes, it would have been better actually.
Whatever was here is going away. So
Your Lordship is kind enough, my lord. That's a request.
no. Parted creates a lot of problem. You see, I'm in a determination which is presently a division bench.
I
And
understand.
there also
No, when,
there's so many so many offshoots.
Yes.
And now we are hearing a APSC matter, a day-to-day hearing.
Then again, that Nagaland matter also.
Then Nagaland matter, and there is another Bachpan Bachao, which is coming up. So
your lordship has gone through the
some of the
No, no, it
facts
is
of
only
the case-
because you see, once I am taking a second appeal, unless I understand what is there,
Yes.
very difficult to
Yes.
take up civil appeal. And
I
when
was
I am out
talking-
of touch.
I was talking to Mr. Mujumdar earlier. Henceforth, I'll stop taking second appeal.
Huh?
Very difficult method.
No, no, do it because the bar requires people like you.
But age is not supporting that. Our age
Age is
not
just a
supporting.
number.
Yes, yes.
You see, every day,
It is-
you see, whenever in this courtroom, can you tell us a name? The oldest, not oldest, I'll not say that. The senior most counsel who is arguing, coming and arguing in the courts. Can you name the person? Senior most in
P.K.
age?
Swami, N.C. Das.
No,
A.K. Bhattacharya.
senior to them,
A.K. Bhattacharya.
senior to him. Today we had the privilege of hearing Mr. Shamsul Huda.
Oh, I see.
Oh, अच्छा.
And I feel very blessed when he comes because of he's 90.
Yes. He's very energetic.
Yes, and he has the same, what do you call, I wish we had people like him. He's so agile and
Yes,
so,
right.
and still prepared.
Very correct language is read. All the time he's agile.
And he's prepared.
That's why you
So-
forgot that he is so agile. Yes.
So therefore age is just a number.
That's true.
Age is just a number. You
Yes.
follow Mr. Huda.
Right. But the second appeal is really problem. That's why, my lord, we're thinking that the
No.
client will be the safest hand.
No, no.
Anyway, my lord, much obliged.
All right. I have interacted with a lawyer when he was almost 90. And gem of a person.
Yes.
So,
Okay.
All right.
item 20.
This appeal is basically on quantum.
Quantum.
Basically on quantum. It is an injury case and admittedly injured claimant was a manager of Pranita Restaurant, Nalbari. And he sustained injuries and according to injury report, there is a fracture of and portion of the patella of leg. Lordship will find the assessment part.
But he was assessed with 40% locomotor disability.
Lordship. The tribunal has awarded the compensation at page 16 of the appeal note.
16.
Page 16.
Yes.
Lordship will find medical expenditure and transportation to the hospital, 1,15,497. I'm not on dispute that. Lordship got it. Yes. Now, Lordship, loss of earning capacity due to disability. I am dispute on that. Loss of earning capacity during period of treatment, there is no dispute to that effect. And loss of amenities of life and loss expectation of life, pain and suffering, and there is a duplication of award. I will place the judgment. This is the factual matter. Admittedly, he was a, Lordship will find he is a manager of a restaurant. So his evocation is manager. He is not a simple worker or labor, anything. Before that, Lordship will, I will take your Lordship to the evidence part of the doctor. LCR Lordship will find.
How much is the calculation done by you? The award is 911. How much according to you it should be?
Because Lordship, in this particular case, loss of earning capacity as assessed by the tribunal regarding disability, it should not be.
Because considering the Supreme Court has categorically stated, disability should be permanent disability which has affected his earning capacity. Supreme Court, as per Supreme Court guideline. But in this particular case, there is a fracture of bone and he is a manager, he is working still. And if that he is a labor, that is other thing. But he being a manager, admittedly, of a restaurant, there is no any physical work to do, and he has not affected his avocation. As per Supreme Court guideline, I'd say. And loss of earning during period of treatment, I have no dispute to that effect. Secondly, loss of amenities of life and loss of expectation of life and pain and suffering. This is a duplication of error. I will place the judgment. Now, I will take your lordship to directly to the doctor's evidence. That is Dr. Prolekko Haloy. Lordship will hand the LCR.
Yes.
Lordship, what? Now, Lordship will the last portion of the evidence on chief. This disability is not permanent. Lordship got it. Last portion of the evidence. That is on evidence on chief. This disability is not permanent. Lordship got it. After 3 years of the patient be asked to appear before the board for review and his disability is to be improved or not. And in the cross-examination, there is a chance of recovery of the said patient. So this disability is not being a permanently affected his earning capacity. There cannot be a loss of earning capacity due to disability. On this point, I will place a judgment of the Supreme Court. How to assess the loss of earning capacity in case of injury case, as per Supreme Court guideline. That is 2014 5 SCC 330, para 12. May I take your lordship to the para 12? May I read? Further, Rajkumar versus Ajay Kumar, this court has succinctly explained the guidelines and head of awarding compensation in cases of disability due to motor accidents. Relevant paragraphs are extracted below. 6. Head under which compensation is awarded for personal injury cases are the following. One is pecuniary, one is non-pecuniary. Less portion. Pecuniary expense relating to treatment of hospitalization, medicines, transportation, nursing, food, miscellaneous expenditures. This is expenses. In this particular case also, we are not disputing the expenditure. Second is loss of earning, which the injured would have made he is not injured, comprising of loss of earning capacity for the during the period of treatment. In this particular case also, we are not disputing the period of treatment during 2 months. Loss of future earning on the account of permanent disability. I am disputing that. After that, Lordship, the Supreme Court has discussed. Secondly, Lordship, future medical expenditure and non-pecuniary damage for pain, suffering, trauma, and consequences of injuries, loss of amenities, loss of prospect of marriage, loss of expectation of life. Now, Lordship, in routine period, routine personal injury cases, compensation will be awarded only under head. One means also expenses relating to treatment. 2, loss of earning, which injured would have been made, has not injured, comprising a loss of earning capacity during the treatment. That is 2A. Lordship got it 2A. And 4 is damage for pain and suffering and trauma and the consequence of the injuries. Where there is a specific medical evidence corroborating the evidence of the claimant, that compensation will be granted under any of the heads, that is 2B, 3, 5, and 6, relating to the loss of future earning on account of permanent disability, future medical expense, loss of amenities, loss of prospect of marriage, and loss of expectation of life. So these compensation, I am disputing this portion, the loss of earning due to disability. There cannot be loss of earning due to disability. Admitted position, there is no dispute to the fact he is a manager of a restaurant. And there is injury is not permanent disability. Injury is not permanent disability, it is a temporary disability for a specific period due to disability. Temporary, and this is a partial temporary disability, not permanent disability. For amputation or loss of hand or loss of leg, loss of eye, this is not. Only temporary disablement because of the fracture injury. This is a fracture injury. So I am disputing the loss of earning due to disability and loss of amenities of life, loss of expectation of life, and pain and suffering. These three are duplication of award. Loss of amenities of life, 60,000. Loss of expectation of life, 60,000, and loss, pain and suffering. These three, as per this judgment, is a duplication. That cannot be awarded. Now, Lordship will find the owner of the Panita restaurant has given evidence regarding his earning. There is no dispute that the income has been proved. So my dispute is regarding this portion, and another judgment on this point of the Supreme Court of India, that is 2012 2 SEC 267. Let's see para 13, and that has been para 13. Let's see, got it.
Yes.
Ascertainment of effect of permanent disability on the actual earning capacity involves 3 steps. Let's see, got it.
Yes.
Tribunal has to first ascertain what activities the claimant could carry in spite of permanent disability, what he could not do as a result of the permanent disability. There is a relevant of awarding compensation under the head of loss of amenities of life. Second step, to ascertain his avocation, profession, and name of the nature of work before the accident, as also his age. Secondly, whether he was prevented or restricted from discharging his previous activities and function, but could carry some other scale of activities and functions so that continues to earn and continue to earn his livelihood. So my dispute is in this particular case, His Lordship, this disability is not permanent in nature, which affected his loss of earning capacity in future. And as per doctor's evidence, this disability is not permanent disability. And Lordship is aware, permanent disability has been defined in the Motor Vehicle Act also. What is permanent disability? In the employees' compensation also, Lordship, the schedule of the employees' compensation, what has been permanent disability has been specifically stated. Schedule of the Workman Compensation Act, Schedule 1.
WC, workman compensation. Workman compensation.
Lordship, what the book? I can hand over the book also.
Let's we have it. Employees compensation, no? Compensation.
One 42 is there, because 142 have the negative in 142. We can charge it so much. Really 142. Permanent disability 142. Lordship, in the Lordship, what is
Yes,
Lordship? Before that, Lordship, I can submit
schedule. Schedule where you are,
Schedule 1, Lordship.
schedule 1. Part 1.
Part 1.
Yes.
Loss of both hand or amputation at the thigh sides, loss of hand or foot, double amputation, loss of sight, facial disfigurement, absolute deafness. These are the permanent disability. And here is also the fracture. And that is permanent partial disablement for a time period, for a specific period. Secondly, Lordship is aware that earlier Motor Vehicle Act 142 was there, defining the permanent disability. Now 142 has been deleted from the Motor Vehicle Act by amendment of 2019. Now,
Yes.
now 142 has been abolished. Considering the fact that the 163 under 1923 Employees Compensation Act is to assess the permanent disability, Supreme Court has interpreted that for considering the assessment of disability, what has been defined as a disability, permanent disability, the Employees Compensation Act will go. In the 163, although earlier 163A, the schedule compensation, the structural formula, they are also stated that schedule of the Employees Compensation Act. So my case is basically this, that he is entitled for compensation during the disability period, during the period of treatment, when he was under treatment, hospital, as well as in his bed. And so there is no question of loss of earning capacity, future loss of earning capacity because of that disability. And doctor has admitted this is not a permanent disability, and this is temporary disability, temporary partial disability. So
Yes,
my
Mr.
submission is limited to this only.
Yes, Mr. Atre.
Yes, Lordship, may I take your Lordship to the cross-examination of the claimant, Lordship?
There are other grounds also, but I have not argued to this point because, Lordship, there is a collision between the two motorcycles. Injured also traveling in a motorcycle, and there is a collision with the motorcycle. I am not arguing on this point because factual metrics, there is no evidence from the claimant side, also from the opposite party also.
Have Lordship got it?
His name is
Roman Das, Lordship.
Raman Das. Yes, got it.
He was examined on Lordship 29/03/2022, Lordship. Yes, Lordship. May I read it, Lordship? Presently, I am dependent. Earlier, I used to work in the pointer student at Paikar Gosai. Here he says, Lordship, earlier, Lordship. The accident occurred on 30/5/2020 at about 5:30 p.m. Accident is of Lordship 30/5/2020, and he was examined. It is important. He was examined on 29/3/2022. On the day of occurrence, I was riding my motorcycle from Jajabari to Pointer Restaurant, and near Sonamoti Chowk, another bike coming from behind knocked me and I fell on the road. I had fracture on my right leg, got injury on hip and chest, and also bruise all over the face. The number of any vehicle number is so-and-so, the registered number of motorcycle number is so-and-so. It is not a fact that the accident occurred as I suddenly take the turn right side. It is not a fact that disability certificate is not genuine. There is no. signature of the doctor who examined me. Lordship, it is not the fact that the exhibit 4 is not genuine and I never had monthly income of 14,000. It is not a fact that, it is important, Lordship, it is not a fact that at present I am totally cured and I am earning, Lordship. He has denied the citation, Lordship. It is not a fact that I am not entitled to compensation, amount of compensation as that I have claimed. Now, Lordship, I would like to take your Lordship to the evidence of the doctor, Lordship.
Yes.
Yes, Lordship. On the second line, Lordship, on examination, I have found.
Doctor is witness number 3.
Yes,
Who
Lordship.
is number 2?
Who is Lordship one? Eyewitness, Lordship.
Eyewitness to the accident.
Yes.
Okay.
CW3, Lordship. He was examined 29/4 only. On second line, Lordship, on examination, I have found that he was a case of locomotor disability, Lordship. The diagnosis in this case is post ORIF fracture, proximity tibia right with stiffness right knee joint. His disability was assessed to be 40%, Lordship, but the learned court below has considered it as 25%, Lordship, for locomotor type in relation to his right lower limb. He was certified as per guideline of the purpose of assessing the extent of the specific disability in a person, including under RPWD Act 2016 notified by Government of India, fight so and so. I have identified him through photo ID. Exhibit 3 is the disability certificate. Exhibit 3 is signature. I know the signature of Joint Director of Health Services, namely so and so. This certificate was recommended for 3 years, Lordship. Now, for a moment, the accident is of 30/5/2020, and they were examined in the year 2022. Now, Lordship, I will take your Lordship to the cross-examination of CW4. Have Lordship got it? Yes, Lordship. May I read it? Today, I have come to the court after receiving the summons. I am proprietor of Pointer Restaurant and Fast Food Situation in Paikarusi. Claimant Roman Das, son of so was employed in my restaurant as manager. His manager on Iman 35/20 in a restaurant, he was gravely injured and was unable to work till date, Lordship. It is important, Lordship. And he was examined on 29/4/2022, Lordship. In cross-part, it is not mentioned that from which date the claimant is working in my restaurant. It is not effective. That is false. So, Lordship, there is admittedly the accident took place on 35/2020, and the persons were examined in 2022 in the 29/4 April. For almost, Lordship, 3 years, the person was not working. So, admittedly, Learned Trial Court has rightly passed the compensation under the head of loss of, under the head, Lordship, the loss of earning due to this disability, Lordship. And Lordship, that Learned Court below has rightly passed as per the judgment passed by the Honorable Apex Court only. It was reflected in the judgment and order dated, Lordship, 31/8/2022, which was reported in 2011 1 SCC 343, Lordship. And
1 SCC
2011 1 SCC 343, Lordship.
Name of the parties?
Name of the parties, Lordship, Rajkumar versus Ajay Kumar. Ajay Kumar and another, Lordship.
It is reflected in the said judgment, Lordship. I have placed the judgment. I have placed the judgment. Here, Rajkumar has been quoted. The body judgment Rajkumar has been quoted, Supreme Court subsequently.
Yes.
So Lordship, my respectful submission before the Honorable Court will be, the learned court
You
below has
are
right.
relying on which paragraph of this Rajkumar?
Lordship, paragraph 6, what has been quoted in the judgment relied by my senior friend, Lordship. The paragraph 6. And Lordship,
Paragraph 6.
paragraph 6, 19. Paragraph 6 has already been read out by my learned senior friend, Lordship.
No, he is reading paragraph 11.
So paragraph 6 of the judgment, Lordship.
Yes.
Shall I read it, Lordship?
Just a moment.
Both has been quoted in the earlier judgment, also para 6 and 7. But para 7 I have not read because there is not 11 in this particular case.
In this Mohan Soni, paragraph 10 and 11 are quoted.
Okay.
6 was not there.
Lordship, in which judgment?
Hmm?
Mahendra Soni. Mohan Soni, Lordship, paragraph number
10
9.
and 11 are quoted.
No, no.
10.
Para 10, 11 and 13.
He's referring to paragraph 6.
Now, of
Paragraph number 6
paragraph
is
6 of the Lordship judgment reported in 2011, Lordship.
Sanjay Kumar.
This is Rajkumar versus Ajay Kumar and another.
That's why
Sanjay Kumar he has quoted para 6 and 7 both in para 12.
Sanjay Kumar is 6 is quoted.
Para 6 and 7 both. But I have not read para 7 because it is not necessary. Para 12. Para 12, para 6 and 7 both has been quoted.
Okay, 6 is there.
And 7 is next, Lordship. I have not read it because it is not relevant.
Six and 7. Okay. Yes, got it.
Now, I am relying in paragraph number 19 of the said judgment, Lordship. 2011, this is Rajkumar versus Ajay Kumar, Lordship.
Yes.
May I read it, Lordship?
Yes.
We may now summarize the principles discussed above. All injuries or permanent disabilities arising from injuries do not result in loss of earning capacity. The percentage of the permanent disability with reference to the whole body of a person cannot be assumed to be the percentage of loss of earning capacity. To put it differently, the percentage of loss of earning capacity is not the same as the percentage of permanent disability, except in few cases where the tribunal on the basis of evidence concludes that a percent of loss of earning capacity is the same as the percent of permanent disability. The doctor who treated an injured claimant or who examined him subsequently to assess the extent of his permanent disability can give evidence only in regard to the extent of permanent disability. The loss of earning capacity is something that will have to be assessed by the tribunal with reference to the evidence in entirety. So in this case, Lordship, the learned court below has rightly assessed the loss of future earning capacity also. The same permanent disability may result in different percentages of loss of earning capacity in different persons depending upon the nature of profession, occupation or job, age, education and other factors. Now, Lordship, in paragraph 24, Lordship, 24 onwards, this judgment has.
This paragraph 19, how does it start?
Sorry, Lordship.
What are the opening words of this paragraph 19?
We may now summarize the principles discussed above. Lordship, in paragraph.
Just a moment. Yes.
Yes. While passing this judgment, the Honorable Apex Court, Lordship, has elaborately discussed about the compensation to be paid in terms of the permanent disability as well as temporary disability, Lordship. And all this has been summarized in paragraph number 19. Now, Lordship, how the amount will be calculated, Lordship, that was been stated in paragraph 24 onwards, Lordship, of the judgment. So, Lordship, my respectful submission will be, Lordship, learned court below has heard nothing wrong while calculating. And if Lordship goes through to the evidence, Lordship, the accident occurred on 30/5/2020, and till 2022, the claimant before Lordship was not working. So apparently, Lordship, he have loss of earning due to disability. Lordship, though the amount which has been the awarded amount which is given under loss of earning due to disability has been rightly passed by the learned court below. This is my response submission based on all the court. And Lordship, the disability is of 40%, while learned court below has calculated is of 25%. Now, taking to your Lordship to the judgment passed by the learned court below. Internal page number 7, Lordship, of the page number 13 of the memo appeal, Lordship.
Yes.
Yes, Lordship. In the third line from the bottom, Lordship, on the contrary, the OP number 1, Oriental Insurance Company Limited, contested the case by filing resistance but failed to examine any witness to prove its case, Lordship. They have not proved, they have not deduced any evidence to the extent that whether the person was working or not. So, Lordship, and of the same.
Sorry, I'm not be able to follow you. Please repeat again.
Lordship, in the insurance company, Lordship, has not adduced any evidence before the learned court below. So, Lordship, they have not tried to establish that the person is not earning. Person is able to earn or not. That has not been the effort has not been given by the insurance company during the trial. And Lordship, in the cross-examination of the CW4, he have categorically stated that the person is not working till date not from on the date on which he was cross-examined. So apparently shows that the person is not in a position to earn. So in my actual submission, Lordship, the appeal is liable to be dismissed. And the calculations were made as per the judgment passed by Sarla Verma and Pranay Sethi, Lordship. At the time, Pranay Sethi.
And what is the formula of calculation? This, in this case, at paragraph 11, disability was assessed and the income
Income has been
the income
considered
of
as 14,000.
14,000 into 12 is 1,68,000. So disability is 42,000.
Disability is 40%. Disability, and Lordship is aware, disability is not loss of earning capacity. That is already established. Disability is not loss of earning capacity. Disability, loss of earning capacity is considered, considering the working capacity of the person. And disability has been defined in the Employees Compensation Act at a separate chart. What
It's
will be
okay, but in this case, let us take, for example, let us assume that this is correct.
disability
So
has
paragraph 11 of the judgment is this, the award is the income shown. Functional disability is 25% of 168, which is 42,000. And
multiplier has been considered as 14. Multiplier method.
multiply is 14.
14. Considering the age of the injured.
Multiplier, where will I get it?
As per Lordship Sarla Verma.
As per Sarla Verma.
As per Sarla Verma.
Considering the age. Folder लेके नहीं आया। दिन में folder लेके आया। Sarla Verma से। Sarla Verma से। Para 42 Lordship.
Verma, what is the citation?
Para 42. Sarla Verma 2009 6 SCC
Just
1
a moment.
2009 6 SCC
Just
1.
a moment. Two 2009 6 SCC
121.
121.
121.
Para 42. Considering the Sushma Thomas case, chart has been prepared. Because Sushma Thomas case, Lordship will be aware that this chart prepared by the Parliament in 163A has been declared as an erroneous. And thereafter, Lordship, Sushma Thomas has guidelined the structural formula. In the new motor vehicle act, Lordship, 163 is not there, Lordship. His chart is not there in the new motor vehicle act.
It's not there. No. So where will I get it?
Earlier motor vehicle act.
Earlier. ये पुराना दियो कौन? पुराना. Yes.
And
Well, I
Supreme
don't
Court
think
has,
we'll have-
Lordship, 3 judges bench of the Supreme Court in Sushma Thomas has said that this multiplier method used by the Parliament in 163 is erroneous. And Sushma Thomas case, Supreme Court has directed to make it correct. And therefore, Parliament has not corrected it. And Supreme Court.
You
Lordship,
have the old book with you?
Lordship, I have. Today, I can give.
I have Lordship.
Just check it up if 163 is there. Chart.
Last.
I'm a bit out of touch.
After a long time, Lordship. This has been, Supreme Court has categorically said this not much, this is erroneous.
Sir, Atreya, we have a query for you. That's why we were looking into it.
Lordship,
Let us assume for the time being that I accept the contention of Mr. Goswami. What I do, I don't know, but let us assume that we are accepting his contention. Under that circumstances, the chart of Sarla Verma, that totally goes because that is for Schedule 2. Schedule 2 is death or permanent disability. So if that goes, then in that case, the accident which is not otherwise fatal, the compensation would be about 1,000 or 5,000, I forgot. The assessment would be that. Supposing I accept this, but then you don't have this multiplier of this even Sarla Verma being applied. And to you, Mr. Goswami, the question would be different. Let us assume you accept your submissions. Then also, this matter cannot be permanently, it cannot be decided by the court, because if the functional disability was for 3 years, then a reassessment has to be made
within after 3 years.
after
Because
3 years.
After 3 years, that has not been reduced by the claimant. It is part
No,
of
that's okay, because he got the compensation. Why would we do the assessment? So it's not required. But now, if we are required to do so, then the alternative would only be to
remand the matter.
remand the matter without adjudicating, because we can't take away the rights of the respondent.
Lordship, besides this, Lordship, he sustained injuries in 2019, I think. 20. And doctor has been examined in 2022.
22.
After 3 years, almost.
No. 22 is 2 years.
2 years.
Plus minus something, but it cannot be 3 years.
And doctor has specifically admitted during evidence on CIF that disability is not permanent.
No, that's okay. But what happens if the disability continues after 3 years? Then it has to become permanent. A temporary injury exceeding for 3 years would be as good as permanent.
But my submission to be, Lordship, considering his Supreme Court has stated, considering his avocation, considering
But if he's out of job, it's a direct result of his.
The Supreme Court has said out of job from the job which he is working, but Supreme Court has categorically stated that he is not performed to do any activities. He said that I lost this job in Pranita restaurant. He's still not working as per his evidence. But I cannot go anything against the evidence on record. I have the photographs. He's wearing shoes and everything. I have the photographs of him, but that was not produced before the tribunal. Considering his photographs, he is not in a person that he is totally disabled. He is not working.
No, that we can't say.
I cannot say because I cannot go against the evidence.
Once we don't have an evidence, we can't jump into
I can-
conclusion.
No, that is well, sir. I'm saying that I cannot go there.
Because it depends on person to person.
That is true.
And
That
Supreme
will-
Court has, that is, I said, Lordship, in case of a government servant, if he do not lose the job, there is no question. There, in case of amputation also, he is not losing the job, he is not getting anything. He's get every compensation under other head, loss of amenities of life, loss of suffering, pain and suffering, everything, but not loss of earning.
Okay, heard.
Lordship, if Lordship may grant me sometime, I will try to find out if any judgment is in my favor regarding the calculation Lordship has pointed out.
No, because if it is, if the disability is not permanent, then Schedule 2 goes away.
Yes, sir, but whether the disability is permanent or not, Lordship, that is to be
No,
assessed.
because
Lordship.
once
So
the
that is
certificate says 3 years, that has to be done.
Yes,
This certificate cannot be now interpreted to say that it's a certificate of permanent disability.
yes, that cannot be done, Lordship.
So the only alternative would be to send it back.
Yes, Lordship.
The amount of compensation which you are otherwise entitled to for the accident, those can be still given to you as an interim award.
I have already 3 lakhs have been already paid. to him.
Lordship, 50% of the award has been deposited before the registry of this court, and out of that 50%, Lordship,
3 lakhs has been deposited.
total 3 lakhs has been given the liberty
It's
to.
okay, but you see, ideally, if we don't know what we'll decide, but let us say that assuming that we accept Mr. Goswami's
Yes, sir.
submission, then you get, what you get is only the compensation in other heads.
Well, Lordship, the evidence was also clear, Lordship, which says that the person is still not working, meaning thereby, Lordship, he is not able to work. And Lordship, being a manager of
No,
a restaurant.
that presumption is also not there.
Yes. No,
That
no,
would be reading something in the evidence which is not there. The evidence does not say that he is not working because he is unable to do it.
that is not there.
So therefore,
That
we
is
can't
not-
read that into the evidence.
That is not, that evidence is not that clear that whether the person is able to work or not able to work. That is not clear from the evidences on record, Lordship.
In the modern age, it may so happen that a man who was able did not get a job, but after disability, he gets under PWD quota.
Many benefit of it. I
Huh?
had got fractured twice my hand. I'm not a disabled Lordship. Fracture injury generally Lordship knows fracture injury is recoverable.
No, we don't know. We just don't know. What happens in a human body, we don't know.
And Supreme Court has
I have a relation who is now expired, just slipped 1 inch.
then hip joint or spinal cord, then it is serious.
No, we expired. With that 1 inch slip, he expired.
So there are many.
So we can't say what happens to a human body. Maybe structure of A may be
human
different
being
from
is
B.
It depends upon man to man, Lordship. It depends
that's why
upon
we
luck
can't-
also
We
sometimes.
can't say. There's another relation of mine who's currently in a very bad shape. He had absolutely nothing what you call on 4th of the month. He had no problem. On 5th, he went to a doctor. He was diagnosed of cancer, and 20
He died
of the month he died, expired.
because of getting the information.
We don't know. Spread over to not a relative, a known person. No, not a relative. But on 4th, nothing is there. 6th, there is a marriage in the house. 6th or 7th, there is a marriage in the house. fifth diagnosed of
That is destiny.
cancer, terminal cancer, and 20 expired.
That is why early detection is very now superior.
Yes. What happens in human body, we don't know now.
Yes, Lord, sir. We cannot predict upon ourselves human bodies.
Okay, we'll consider, we'll take it up. If you can deliver order, we'll take it up next week. Heard Mr. S.K. Goswami, learned counsel for the appellant, and Mr. Atreya, Mr. Atreya, I forgot your first name.
S.N. Krishnatya.
S.N. Krishnatya, learned counsel for the respondent. Stop. Arguments are concluded. Next, list on so and so for orders. Make it make it 6th of June. For deliver orders.
Obliged.
Other matters will not be able to take up. This will get adjourned.
Item 22. Suit for specific performance was decreed. There is some urgency.
22.
Our suit was decreed.
Okay, the other matters which are left over. So due to positive matter could not be taken up. List on Monday.
Item
All of the 2 or 3 matters which have been could not be taken up. Go on Monday.
month.
Yes. Mr. Datta, anything?
21 is there.
All of it adjourned to Monday. Whatever we couldn't take up today, adjourned to Monday.